Okay, I think we're ready to reconvene the adjudicatory hearing on the MGM application. Not quite. Counselor, do you want to introduce your next witness?
Mr. Chairman, if you don't mind, I'll just jump right in because we're still on the Terry Christensen matter.
Okay.
And Nick's already introduced me, so I'll just jump right into the meat of this issue. I first want to say that from the onset of this investigation, I did support, and in fact, I demanded a complete investigation. And since I had interactions with Terry Christensen, which we'll outline in detail, I made sure, as Mr. Hernandez mentioned, I was walled off entirely from that investigation. And I did support all the recommendations of the special committee, and in fact, I implemented many of them myself. As you heard from Mr. Hernandez, both the company and, more importantly, me personally made several very bad decisions. Yes, based on bad advice, but nonetheless, we're responsible for our own decisions. I certainly am as the chairman and CEO of MGM. And I exercised, I think it's obvious today, looking back, I exercised poor judgment. Even though a lot of what happened was sanctioned, I guess, by legal advice, I know that I, as the chairman and CEO, should have been more inquisitive. I should have asked more questions. Looking back at it now, I obviously deeply regret I did not, but the fact remains I did not, and I regret that. And that really begins from the moment Mr. Christensen was indicted. I'm not particularly, well, first off, I'm not a lawyer, and I can't split the difference in my mind between indictments and convictions, and it just was a bad idea from the very, very beginning. None of us should have had any contact with him. I certainly shouldn't have as a board member and the CFO at the time, or certainly when I became the chairman and CEO at the end of 2008. And you have to be asking yourself the question, why did I do this? I've asked myself that question so many times since the Wall Street Journal article touched off the very large investigation that was undertaken. And I don't have any excuses for this. It was wrong at the beginning, then it's wrong now. I have to at least reflect for a very brief second on the environment by which I was thrust into this job. Not to over-dramatize it, but it was a horrible time for our company, for my management team, for myself personally. The amount of stress that we were under was epic, unprecedented, resulting in several threats against my family and my life because we had laid off so many people. It was a harrowing time. There's no reason to expect that I should have acted differently. I should have. I should have acted differently from the beginning. And I'm a better person for it today. I believe our company is. And we have learned from this incredibly bad situation. And I think that doing it all over again could never happen again, given the governance we have in place, given the quality of the board members, the independent members we have today, given the mentoring that I've had since I became the CEO now several years ago, and the kind of person I have, and the fact that those scars of the recession, and most importantly, the shame that I have that I did conduct myself in an inappropriate manner, will be with me for the balance of my career. So I wanted to state that in the beginning. I know there'll be many questions, and I'm happy to tackle any of them that you may have, or you, sir.
ahead.
Okay. Well, Mr. Murray, good afternoon. As I did with Mr. Hernandez, I want to take you back in time a little bit to before the time when you were CEO, but back to the time when Mr. Christensen was indicted, which is back in February of 2006. Now, could you describe for the commission your role in the company at that time?
Yes, I was the executive vice president and CFO of the company.
Okay. And also, you had a position on the compliance committee as well, correct?
I did, yes.
Okay. Now, do you have the book of exhibits in front of you? I just want to draw your attention briefly to exhibit number 5, which is the press release that the company issued shortly after the indictment.
Oh, thank you. I have it here. Yes, I have it here.
Okay. In your sworn testimony before today, you were asked some questions about that press release. Do you recall that?
I do recall it, yes.
Okay. And it'd be fair to say that you were given a draft of this release in advance and that you indicated by email that you were fine with it. Have I said that correctly?
I had several questions on this press release, which I'm happy to describe. I was fine with the content of what I was responsible for.
Okay. Well, maybe you could elaborate that and tell me if you had questions about it, what the questions were, and what parts of it you were fine with.
Yes, as the CFO of the company, I was part of the internal circulation of press releases, particularly press releases of a financial matter, because I was, at that time, the chief investor relations contact for the financial community. This press release was not generated from my office. It came through, I now believe, through our general counsel, our then general counsel, and through PR. The questions that we had, meaning myself and my financial team, was why such a press release would be issued at all. This was a subject of quite a bit of debate internally over the period of a few days. I was overseas, I think, at the time when this occurred, and ultimately it was concluded by our chairman and CEO, the body of which was a quote from him, that we should issue this press release. I cannot say that it was fully supported internally.
The words that you used in your email, this may be helpful, is Dawn opened it for me. You recall you were having a terrible time opening the document. It sounds like you were in an airport at the time or somewhere. And I think it's fine. The meat is in Terry's quote, so hopefully he likes that.
That's correct.
Okay. Which is in substance just what you were telling the commission, that Terry was going to have to take responsibility for his own quote. Isn't that fair?
That is correct.
Okay. Now, the statement is made in the release, we are confident that after a trial on the merits, he will be exonerated. Do you see that?
I do.
Okay. Do you know at that time what the basis for that confidence was?
I do not. This was attributed directly to our chairman and CEO, and it was a quote from him.
Okay. Are you aware, Mr. Murrin, that at this point in time, February 2006, the company had done any independent investigation of the facts that supported the indictment?
I'm not aware of that.
Are you aware there had been any effort to discuss the matter with Mr. Christensen at this point, the facts supporting the indictment?
I'm not aware of that.
Is the chief financial officer, Mr. Murrin, did you ever suggest at this point that there be some effort made to get a handle on what these facts were?
I did not, no.
Okay. So following Mr. Christensen's indictment, then there were then a series of meetings of the compliance committee, and there's been some discussions earlier about them today. There were 3 meetings in rapid succession after the indictment.
That's correct.
Okay. And I take it that during this period of time, you were on the compliance committee, but you were unable to attend any of these meetings?
That is correct.
Okay. And did you play any role, Mr. Murrin, in the initial formulations of the restrictions that the company was going to place on Mr. Christensen's involvement?
I did not.
And then, did you play any role in the subsequent relaxing of those restrictions?
I did not.
Let me then fast forward to January of 2007, and I asked Mr. Hernandez these questions, and I'll ask them of you as well. Do you recall that in January 2007, the New York Times ran a very extended story about the criminal case against Mr. Christensen and Pelicano, and in fact published significant parts of the transcript of the tapes?
I did not recall that, and I was not aware of it until you brought it up today.
Are you aware that even today, you can go on the New York Times website and click on the audio link and hear substantial portions of the Christensen-Pelicano conversations?
No, I was not aware of that.
Do you recall whether anyone at MGM was aware in early 2007, when this story broke, that the information supporting Mr. Christensen's criminal indictment was now a matter of public record?
I was not aware, no.
So as you're sitting here today, you have no recollection of anyone at MGM being aware that the New York Times had basically put all these tapes onto its website?
That is correct.
Mr. Moran, let me then advance forward to the criminal trial itself. The trial took place in August of 2008. So at this point, were you still the CFO, or had you made the move to CEO?
I was president and CFO. Oh, no, I'm sorry, I was president and chief operating officer in 2008.
Okay. Now, are you aware, let me just ask you, were you aware at the time, in August 2008, that the tapes recording the conversations between Mr. Christensen and Mr. Pelicano were played publicly at his criminal trial?
I was not.
Okay. Did you follow the trial in the news?
I did not.
Let me draw your attention to exhibit number 7, if I could. Actually, I'm not sure that's the right exhibit, sorry. Oh, yeah, it's exhibit 7. Pardon me. Do you recognize exhibit 7? 1 second.
1 second, please, we're getting it.
Okay.
Yes, I do recognize it.
If you could just read to me the first, well, tell me what the letter is, if you could.
The letter is addressed to a judge, Judge Fisher, and it starts by saying, "I'm writing you today on behalf of Terry Christensen in connection with his pending sentencing."
And could you read the next sentence, please?
Sure. I'm aware the legal proceedings against Mr. Christensen have been following the trial in the news.
Okay. And then on the next page, that's your signature on the letter, correct?
It is, yes.
So does this refresh your recollection that, in fact, you did follow the trial in the news?
I followed it vaguely. I don't know the details of it.
Well, this was a letter that you submitted in connection with Mr. Christensen's sentencing, correct?
That is correct.
Okay. And Mr. Christensen was, in fact, convicted, correct?
That is correct.
Okay, and he was, in fact, sentenced, correct?
Yes.
He's sentenced to 3 years in federal prison?
I believe so.
Okay. Given your, strike that, are you aware, did you ever have occasion to read or to listen to some of the remarks that the judge made at Mr. Christensen's sentencing?
I did not.
So you're not aware that the judge declared that Mr. Christensen had taken no responsibility for his crimes,
I did not.
and that he showed no remorse for his crimes,
It's the same answer.
and that, and I'm quoting here from her remarks, the men on those recordings did what they did because they could and they enjoyed it,
If you say so.
and that they deliberately, repeatedly, and happily violated the law.
Is that a question?
Did that refresh your recollection about?
No, it does not.
Okay. Now, following the playing of the tapes at the criminal trial and the sentencing, I don't want to put words in your mouth, so let me try this and you tell me if I've got it right or not. Would it be fair to say that following the sentencing, you relied on your general counsel for legal advice about the extent to which Mr. Christensen could continue to be involved in MGM's affairs?
That is correct.
Okay. And you have said today, and on the record in words or in substance, that Mr. Jacobs failed to tell you that that at least as a regulatory matter, you should cut off all contact with Mr. Christensen.
Yes, as we've said earlier, both myself and Mr. Hernandez, we inappropriately relied on our general counsel. Our general counsel at the time, by the way, asked me to write this letter. And I did so, as did many board members of MGM. I wish I had followed the case more closely. I did not, as I've just told you. But I had known Terry Christensen, Mr. Christensen, for many years, and I had an empathy toward him by virtue of the fact that I had known him a considerable period of time. But throughout that period of time, I was relying upon, inappropriately as it turns out, the counsel of my general counsel.
Okay. And you said in your sworn testimony in this matter that in the absence of getting any advice from Mr. Jacobs about, legal restrictions on your ability to communicate with Mr. Christensen, that other than that, you never had any concerns about interactions on MGM matters with Mr. Christensen, that your concerns were of a legal nature, and that you weren't getting any advice from Mr. Jacobs on those matters.
I did not, no. I communicated with Mr. Christensen primarily as a financial advisor to Mr. Krikorian. I did not seek any outside advice outside of my general counsel that whether or not that was appropriate, and I should have done that.
What I'm interested in, Mr. Murren, is aside, from the legal advice that you weren't getting from your general counsel, did you have any concerns following the trial and following the conviction, following the sentencing, that Mr. Christensen just wasn't trustworthy? Did you understand the question, that aside from the legal issue, that he just wasn't somebody you should be dealing with, because you couldn't trust him?
Looking back on it, obviously, as I said, I regret the interaction. It wouldn't happen again. But at the time, I was not properly sensitized to the fact that I should not have any interaction with him. Setting aside the legal basis for that, the optics of it were horrendous. I understand that now, but I was not sensitized to it at the time.
But aside from the legal stuff and aside from the optics, did you have any concern that this is just not a guy who you could trust with confidential, sensitive MGM business matters?
I was not sensitized to it at the time.
Let me ask you a few questions about Mr. Krikorian. You described your relationship with Mr. Krikorian as close. Be fair to say?
I've known Mr. Krikorian since 1998, and I've had the pleasure of talking to him and seeing him on a number of occasions.
And I take it from your sworn testimony that you never discussed Mr. Christensen's indictment or conviction with him.
That is correct.
So I take it that you never said to Mr. Krikorian in words or substance that, you know, gee, given Mr. Christensen's significant legal problems here, it's probably not the best person to be representing your affairs on the MGM board.
That's correct. I did not say that.
Why not, given that you did have a relationship directly with Mr. Krikorian?
As the record states, I joined the company in 1998 as the CFO. At that time, the chairman and CEO was one of the most highly regarded gaming executives in our industry with decades of experience. He was the man I reported to. The outside counsel at the time was the outside counsel that had represented the firm literally for decades. Mr. Christensen was on the board, I think from the inception, but certainly for years before I joined. And our general counsel, since 2000, was somebody that I worked with from that period of time forward to the period of time in question. I exercised poor judgment by not using my own independent thinking, but I based my decisions at the time on the fact that there was a tremendous amount of precedent history here with a public company that went public back in 1992, MGM Grand Inc., and with a board of highly experienced men and women, particularly the chairman and CEO of the board at that time, a highly regarded gaming executive. And for those reasons, I did not properly exercise my own independent questioning of my boss at that time, the chairman and CEO, or the general counsel, nor did I seek outside advice outside of our outside counsel, which clearly was a massive conflict of interest, which I think Mr. Hernandez very exhaustively outlined today.
But there was a period of time after you became the CEO that Mr. Christensen continued to have some significant involvement in the company, correct?
I would not call it significant. He did have involvement with the company.
Okay. And this was after his conviction, correct?
That is correct.
Okay. And so my question is, as CEO at that point, as the person responsible for the company, didn't you think it appropriate, and weren't you in a position to raise a red flag, and in particular talk to Mr. Krikorian about the person who he had keeping an eye on his affairs at MGM?
I absolutely should have done that.
I have nothing further. Pardon me. No further questions.
Okay. Anybody here, questions?
Yeah, I had a couple of questions. Mr. Marin, how are you?
I'm well, thank you.
I just had a couple of questions, and I've been listening closely to your explanations, but a couple of things struck me when I read excerpts of your testimony. And one was when you state that someone else had to tell you that this was a problem, that dealing with Mr. Christensen after his conviction was an issue, and you mentioned that here. But then when you were told it was a problem, there was several more interactions, and I think the one interaction of note is dealing with New Jersey regulators when this was a significant issue for New Jersey. Is that correct? The Christensen matter?
I believe you're referring to the time when we conducted our full investigation, which was at the end of 2009, and from that period of time, I had no and have had no interaction with Terry Christensen. I believe the matter you're referring to happened before that.
I'm just reading on the bottom of page 84 from your transcript, sir. This is when you directed Mr. McManus to call Christensen and advise him of the details of a meeting you had earlier that day with DGE.
Yes, I recall that. That occurred before the investigation. The investigation occurred after the Wall Street Journal article, and that was in late 2009.
But New Jersey was speaking to you about this matter, correct? This is one of their concerns, or no? Not at that time?
No, it was not. And that was, if you recall, that was, I think, John, was it in July of 2009? Or,
Yeah, the interaction you're talking about, there was, I think, one in July and then one in early September of 2009. If it was the meeting, it was early September.
Yes.
The Wall Street Journal article was about 2 weeks later. So at the time, the New Jersey matter was exclusively related to our association with Pansy Ho and the compliance issues that were involved with that.
Okay. Okay, thank you for clearing that up. So New Jersey's questions about this matter arose later.
that is correct.
Okay. Just had one other observation, sir. You gave a pretty eloquent explanation of the firm and the values of the firm earlier, and you really emphasized diversity. And I just the optics from where I sit, I look at maybe 3 or 4 rows of folks from your company here. Is there a woman here, sir, representing your company?
Yes, Kelly Tuckey is here.
Okay. Okay. Thank you for pointing that out to
Thank
me.
you.
Point stands, nevertheless.
Point taken.
I had a few questions, Mr. Murad. In 2006, you were the executive vice president,
That is correct, sir.
and you were the CFO,
That is correct.
and were you a member of the board?
I was, yes, sir.
And you were a member of the compliance committee.
I was appointed to the compliance committee.
Now, when Mr. Christensen was indicted in the middle of February, the board reacted to that indictment by accepting his resignation from the board. Is that right? About a week later?
That is correct.
And then there was a compliance committee meeting at the end of March, the following March, and you were not able to attend that meeting.
That is correct.
And it was at that meeting that those recommendations for removal of Mr. Christensen as the billing partner and the like were made. Is that right?
That is correct.
How many members of the compliance committee were there at that time?
I do not recall the specific number. It was 6 or 7, would be my guess.
It's a small group.
Small, and this was before we developed the independent
I
compliance
understand,
committee.
but it was a small group of people.
That's correct.
And the compliance committee was responsible for overseeing compliance for the whole MGM organization, right?
That is correct.
And the Compliance Committee prepared minutes of all of its meetings
They did.
contemporaneously,
I think so, yes.
essentially contemporaneously.
Essentially, yes, sir.
Yeah. But you didn't read the minutes of that meeting, the March 31st meeting, for 3.5 years. Is that right?
That's absolutely true.
And so you didn't know what, if anything, the Compliance Committee had recommended with respect to the director who had just resigned because he'd been indicted.
No, our internal compliance committee was peopled by folks from law enforcement and had legal backgrounds. I, in hindsight, was poorly equipped to be on the compliance committee, and I did not attend those meetings, nor did I read the minutes, and that was a failure on my part.
Did anyone mention to you that the Compliance Committee had taken some action, never mind the detail, with respect to made some recommendations with respect to Mr. Christian?
I was aware that there were restrictions as to the interactions with Terry Christensen as a billing partner. I don't recall when I was aware of that, and I certainly did not recall at the time when the restrictions were loosened in any way. That, in hindsight, after the fact, seems bizarre and really wrong to me.
The restrictions were the subject of another meeting a month and a half later, were they not, or a month later in early May?
That is correct.
And it was at that meeting that the Compliance Committee considered recommendations for loosening those restrictions because they were, in the view of someone, Mr. Jacobs or someone else, too harsh. Is that right?
That's correct.
And you were not able to attend that meeting either.
That is correct.
And minutes were, again, contemporaneously, or essentially contemporaneously prepared. Is that right?
That is correct.
And you first read those minutes 3.5 years later.
Yes, in late 2009.
And again, did you hear from anybody that the restrictions that you understood had been imposed earlier had been relaxed?
No, I do not recall that.
Did you see Mr. Christensen at board meetings thereafter?
I saw Mr. Christensen in board meetings in 2006 and 2007. I never saw him in a board meeting once I became the chairman and CEO at the end of '08.
Did it occur to you that his presence at those board meetings was inconsistent with the restrictions that you understood the Compliance Committee had recommended?
It did not. I did not fully understand the restrictions, and it did not occur to me that his presence would be in conflict with the restrictions.
And yet you didn't go to the minutes of the Compliance Committee meeting to see what the restrictions were?
That's correct.
Why?
I was, as I said earlier, not focused as I should have been on compliance. I relied upon members of that committee that were more experienced in this matter than I was, law enforcement, attorneys, regulators, auditors. I relied upon the advice of my general counsel, which is not in any form of an excuse. I'm just trying to respond to your question as to why I did not do that. And I should have.
Mr. Mackey asked you questions about a New York Times article that was published in 2007 with respect to this, and I understand you're unfamiliar with that. If assuming that article was in fact published and it has the characteristics that Mr. Mackey described, both of which I assume for purposes of this question, is that something which should have been brought to your attention?
Yes, absolutely, looking back on it. I'm not the person today I was back then. I was an inexperienced person. I cannot say for sure it would have occurred to me that it should have been brought to my attention then. Now I could affirmatively say it absolutely should have been brought to my and any board member's attention.
It's the kind of thing that a corporate, that corporate governance would require systems to be in place to have brought to your attention.
Absolutely.
That's an awkward question, but
No, I absolutely agree with you.
you didn't follow, you said, in response to Mr. Mackey's questions, the trial very closely.
I did not, no.
And were you interested in the allegations and how they were playing out in the courtroom down the street?
My best feeling at the time was frankly sadness, because this was a board member. I did not engage myself learning enough of the facts. I just was focused on someone who had served on a board before I joined and while I was there, and we were assured as board members that he was always innocent. It was something, looking back, was a very naive point to just take at face value. Nonetheless, I can say from my standpoint, speaking for myself, I did believe he was, because I was told that he was by people that knew him better and that were in a position of experience in the legal profession. It was a very naive point of view looking back.
At the end of the trial, when the sentencing time came, you signed a letter that was sent to the judge in which you talked about Mr. Christensen's positive characteristics.
I did, yes.
And in that letter, you said to the judge, among other things, "I have followed the trial."
I did say that, yes.
Why did you say that?
I followed it at a very superficial level, and if I was not clear before, I'll just restate the fact that I did not follow it daily. I did not follow the proceedings. I did not listen to testimony. I didn't even know that there were recordings that could be obtained. I just knew that he was on trial, and I followed it at a very 30,000-foot level.
So by the time of sentencing, and at the time you wrote the letter saying you followed the trial, did you know the substance of any of the testimony or the evidence or the nature of the interceptions or any of that detail?
The detail I knew was that the allegation was that Mr. Christensen had hired a private investigator that, it turned out, illegally wiretapped an individual. I was told that that did not occur, and that I was also told that he was innocent. Those were the facts that I had. And then,
But those were facts that were tested before a jury, right, in the trial?
That
That's what
is
the trial
correct.
was all about.
that is correct.
Right. But you knew nothing of the evidence that the jury had been presented with, or what the judge had said, if anything.
That is
about
correct. And even after he was convicted, we were told that he would be vindicated in appeal. And again, all of us, including myself, should have delved into that further.
So when you said I followed the trial, it was really this high altitude, if we'll call it, following that you were referring to.
That is correct.
Then, after Mr. Christensen was convicted, you continued to have interactions with him about some MGM matters. Is that right?
That is correct.
And you, in fact, enlisted his help in your own salary relationships with the MGM board. Is that right?
That is not correct.
You enlisted Mr. Krikorian's efforts,
Yes, I did.
and Mr. Krikorian thereafter you were contacted by Mr. Christensen with respect to those
That is correct.
efforts, and discussed those efforts with, or your desires with Mr. Christensen.
All I discussed was that I was unhappy that I was promoted months beforehand, and I had yet to be able to secure a contract that had been promised to me months beforehand. I told him I was having frustration with my compensation committee. I told him I was frustrated.
And you told him that in the expectation that he, through Mr. Krikorian or independently, would be able to help resolve the problem?
No. I had no expectation that Mr. Christensen would help me in any way. I was venting.
Did you have any expectation that Mr. Krikorian would help you?
I had expectation that my board would help me, including Mr. Krikorian. I was vexed at why it was months later, in the throes of this crisis, that we couldn't come to a simple contract. And I made my point clear to all my board members, including Mr. Krikorian.
So you, if I understand this correctly, you called Mr. Krikorian to express your frustration.
I don't believe I called him to express frustration. I believe on a conversation I had with him, I expressed my frustration.
Fair enough. And thereafter, Mr. Christensen contacted you to talk about that subject, the subject of your frustration.
That's right. He called me to say, what is going on with my contract? And I told him that I'm frustrated. I do not have a contract, and it's a matter of the compensation committee, but I was frustrated that it was taking so long.
And you told him that without any expectation that he would facilitate resolution of the problem?
That is absolutely true. I have a very strong relationship with my board, including the compensation committee. I held no belief that I needed any outside contact with any member, and certainly I wouldn't have reached out to him on any matter, certainly on a personal nature like this.
Even though he was, you knew, closely connected to Mr. Krikorian?
Yes, I knew that he was closely connected, but I did not seek his advice or his input at all.
Did Mr. Christensen, to your knowledge, attend board meetings after his conviction?
I've learned later that he did, but that was only after the investigation revealed that he was in a telephonic meeting that we had after his conviction.
And you knew nothing about that telephone meeting?
I knew nothing about
his
that.
presence at that meeting?
Absolutely, I knew nothing about that.
All right, sir, thank you.
Thank you.
Anybody else?
Mr. Chairman, at this point, if it would be helpful to the commission, I'm prepared to offer into evidence the New York Times story that I've questioned about and that the MGA witnesses have testified they had no knowledge of. It is described in the investigative report at page 348. If that would be helpful to the commission, I'm prepared to offer it.
Yeah,
I can share a copy.
I'd like to see that, yeah. Just one more question, Mr. Mayor. Oh, sorry. Oh, okay.
I'm just going to show it.
We get that too.
Sure. Unless there's objection. Is there any objection?
No objection.
Okay.
I just had one other question. I should have asked this of Mr. Hernandez as well. Thank you. With all the new systems that you've got in place and the personal and professional learning that you and Mr. Hernandez talked about and so forth, with admirable, by the way, candidate, has the system caught things that you would otherwise might have been embarrassing or problematic? And can you give examples? Is the system working? Systems working?
Yes. I would say first that there's been a tremendous amount of growth within our company and myself. One of the positives that was not brought forward in this dialogue was I received, as Mr. Hernandez mentioned, stern and comprehensive counseling at the result of this investigation. I'd also call it mentoring too, though, because Mr. Hernandez and also former Governor of Nevada, Governor Gwynn, were my two counselors and mentors. He sadly has passed away now, but he and Mr. Hernandez spent a considerable amount of time with me, and one of the learnings of that was to have far better communication with my board. I don't think I was doing a good job of that either, by the way. I was managing down and managing around the organization, but interacting with my fellow board members, both independent and inside board members, was not something I was doing enough of. As it relates to, perhaps you want to tackle one or two of the, can I defer to Mr. McManus on a couple of real-life examples how this is working?
Thank you. I think, look, our compliance program and our serious approach to it, certainly it's almost hard to find out what you've prevented if it doesn't happen. But one question that came up earlier was the independence, whether we put somebody on our board who was a partner at one of our law firms. And oddly, that is the type of thing that I think our new processes have prevented. When we've been through our board recruitment and board evaluation process, one of the key criteria is that we only recruit independent board members. In fact, we have a sitting board member, who I won't name, who's an attorney who had a possibility to associate in one fashion with a law firm who did a small amount of work for us. And we engaged in a considerable dialogue with that board member about the issues that would arise, both under the New York Stock Exchange rules and the implications that could impact her independence for a committee or otherwise. And ultimately, we had a very good process where we just concluded, as did the board member, that they weren't going to pursue that relationship because they didn't want to compromise the independence. And I think that's a strangely on-point example. There are, I'd say, numerous occasions where our compliance function has just worked appropriately, and in my estimation, having put considerable thought into these issues, communication was the biggest single problem. And now I would say that I can tell you with confidence, we have double and triple redundant systems to make sure that the compliance committee knows what the board is doing, the board knows what the compliance committee is doing, and key members of management are continually keeping them all informed. So for me, that's the essence of it.
And I would just add that the chair of the Nominating Corporate Governance Committee is the former chairman of the Nevada Gaming Control Board. And we're in fact in a search now for yet another independent director, and I've insisted, by the way, it'll be a minority candidate, Commissioner Cameron, because we only have 2 females on our board currently, and that's going to change this year coming. But we spend a considerable amount of time on this effort. And I would say that Roland hit it very well, not to belabor it during the day, but the communication between this independent, truly independent, the compliance committee does not report to the audit committee. It literally reports right up, straight through to the board, and that communication has been preserved and strengthened since the end of 2009. And I would say that the combination of the robust nature of the compliance committee, the interaction with the audit committee, and if you want to find a board member that spends a considerable amount of time on detail, sit in an audit committee chaired by Roland Hernandez. It is an all-day affair, as my colleagues behind me would attest to. That it's just incredibly specific and very dynamic, because we tackle different subjects every single audit committee, and he, in turn, as all chairs of our board committees, report to the board the following day.
Great. Anything else?
I had a couple, Mr. Maron, a couple of quick questions. I think you already answered one of them. You talked about that period after you became CEO, 2008, probably not the best time to become a CEO of anything. But you talked about mentors, and I'm assuming it was those 2 gentlemen who were your board members who Was there anybody else, perhaps outside the company or another board member that was helpful to you?
We didn't get into this in the presentation. I think it'll come up at some later date, hopefully, but I've dedicated my work product to being the best CEO I can be, because I've really worked on the concept of the tone at the top. We talked about diversity, I think, in my introductory remarks, but I really reach out and try to find people that can inspire that type of leadership. I do so within the board with some of our independent members, and I sit on several, I'm the chair of the American Gaming Association now. I'm on the Brookings Institution. I go overseas often on CEO roundtables, and I have made it an effort to reach out to more experienced CEOs than I understand the abrupt nature of my promotion back in 2008, and I think the company has grown alongside myself. But the mentoring aspect is something that's very important to our company. I'm now a mentor of employees within our company. The mentoring program is very robust. We have tremendous leadership programs within our company for folks coming out of school or changing careers. And mostly, I've found through our diversity efforts, frankly, I'm finding some of the best examples of the best possible character that I need to surround myself with, and that's what I've tried to do.
One additional question, and I asked Mr. Hernandez this in terms of the steps that you took. You reinforced the code of business ethics. Were there, maybe you have some insight into whether there were specific measures or strategies or provisions that you adopted kind of after this Mr. Christensen's indictment and conviction? Anything that changed within the code of business ethics other than obviously, making employees and management and the board aware of the provisions within the code, but were there any specific changes that went into that?
Yes, we reading through it with a much different eye back in 2009, we felt it was a little too general in some areas. So we brought a sledgehammer to some of these points to just make sure that no one could be ignorant of these principal points of doing nothing that would impair the company's reputation in any jurisdiction in which we operate. It was fairly general because it's hard to capture in a code of conduct, every specific do and don't. But we have a more specific code of conduct policy today, and we provided both the current one and how it's evolved. I do have to say, though, that it's my belief that a code of conduct is absolutely important and critical, but literally its culture is more important than that. It's in the standpoint of, are you creating the type of corporate culture that creates good decision-making for all of your employees? Because they're making hundreds of them a week, and not all of them can be viewed through the lens of a code of conduct general statement. They have to be very specific to their own ethics and their own integrity. And that's why I'm so disappointed in myself back in 2008, because the tone is at the top. I set that tone as the chairman and CEO. And I think that you would find in surveying our employees today, they're acutely aware of how vital that is to our organization and how it's principal among everything else.
Thank you.
Anybody else? Gentlemen, all set?
Mr. Chairman, may I have 1 second,
Sure.
please? Mr. Chairman, I'd like to offer into evidence as applicant's Exhibit 2. And I apologize, I do not have enough copies to hand around.
That's all right.
So perhaps the best way to handle this would be for Mr. Murrin to take a look at it and tell me what it is.
Well,
I'm going to embarrass him right now.
it sounds like I'm bragging on myself, which is not my nature, but I really think this is a team award, but CR Magazine just recently, it was about a month or so ago, awarded me with the Responsible CEO of the Year award. But this is a team award, I would have to say, and I'm very proud of our effort. But I think this speaks to, without over-dramatizing it, speaks to the type of culture that we're trying to create in our company, and one I'm extremely proud of.
Thank you.
Thank you. Okay, we're next. Thank you, Mr. Murrin. Are we ready for our next witness?
Do you want me to sit back? Oh, sorry. Yeah, just take this. Yeah, thank you.
Next witness is John McManus, Senior Vice President. Did I get that wrong?
You just demoted me.
Executive Vice President, General Counsel, and Secretary. John, please tell us about the company's current compliance plan.
Okay.
Briefly.
Yeah, we've heard quite a bit about it through Mr. And first, thank you for letting me be here today. It's an honor to appear before you. Good afternoon. I had written good morning in my remarks.
Optimism.
Yeah. You've heard quite a bit today, mostly during Mr. Hernandez's testimony, about the evolution of our plan. Currently, we have a plan that has three independent members, former member of the Nevada Gaming Commission, former special agent in charge at the Las Vegas office of the FBI, and a former academic and founding law school dean for the UNLV Law School. So we do have a diverse group that with bringing different skills to the table. Our compliance plan itself is essentially like a charter or a constitution, and nobody ever seems to describe the compliance plan and the committee exactly right, because it's sort of a unique concept. It's this body that exists by its own document, and it doesn't really report to the audit committee. It doesn't really report to the board. The members are appointed by the audit committee, but it's truly independent. And there are certain circumstances that are described in the plan where you need the authorization of the compliance committee to move forward. So that's where we're seeking their advice and counsel. And it's something we're quite proud of. One thing I would like to say is our plans have evolved since our first one in 1999, where we had one member who was independent. And over time, usually through merger or acquisition from the company, where we adopted other companies and sort of meshed them together, or frankly in times of failure, such as the Christensen matter, or some of the shortcomings in our process related to the Pansy Ho partnership that were outlined in the New Jersey report, we've made changes. And the most important one was in 2007, where we came about with the 3 independent members. And then following the Christensen, we got the liaison from the audit committee, which was the prime feature. So that helped with the communication back and forth.
Just a couple of quick questions. Who's the compliance officer?
The chief compliance officer is Tom Peterman, who is a longtime practicing gaming attorney in Las Vegas and has been with the company for about over 20 years.
And who does he report to?
He reports to the compliance committee.
And who hired him?
The compliance committee.
Was MGM the first company to have an independent member on its compliance committee?
I believe that it was.
To your knowledge, does any other gaming compliance committee consist solely of independent members?
Not to my knowledge.
Tell us,
Not to my knowledge at the time.
tell us about some of the other corporate policies that the company has in place.
Yeah, we have the code of conduct, which we've discussed at length as well, which is sort of the ethical charter of the company. Then we have extensive policies for anti-corruption. Again, we refine those from time to time. We also have extensive anti-money laundering policies. We have, obviously, gaming policies, things of that sort. We also, with our Macau property that we'll hear a little bit more about, we have an effort to make sure that things like AML and anti-corruption work hand in hand with what they do. We recently had occasion to have the two boards of the public companies in the same place at once, and we held a joint session where we talked about some of the common efforts in global security and anti-money laundering and anti-corruption.
Chairman Crosby asked about examples of situations. Would you like to talk about Vietnam?
Sure. In, I believe it was 2008, we entered into an agreement whereby we would manage a casino that was being developed in Vietnam. And Vietnam is an emerging gaming jurisdiction. They have small sort of slot parlor type of casinos right now with little or no regulation. The developer of this project got permission from the government to develop a large-scale project on the coast of Vietnam. We entered into these agreements with the expectation that Vietnam would be adopting a number of laws, would be demonstrating a commitment to gaming regulation and compliance, and we worked with the developer for several years, up until earlier this year, in fact, after we submitted our application. And we monitored, we assisted along the way. We weren't satisfied with the progress that was being made in a number of important areas in Vietnam. We addressed this with the owner. We tried to take helpful actions to assist with, sorry.
Vietnam calling.
I guess I've upset the ambassador. But in any event, okay, sorry.
Why don't you just answer it?
In any event, after this process, in close consultation with Jim and other members of senior management, we made recommendations to the Compliance Committee, having kept them informed along the way, as well as the board. Management ultimately decided that we were not comfortable with that regulatory environment, not because there was anything wrong with the people of Vietnam or their commitment, but it hadn't advanced in a way that we had comfort. So we terminated that management agreement under our rights, which created some reputational risk for us as a developer and manager of projects to cut that tie. But for us, it was a risk that we weren't comfortable with in that environment, and we made that decision.
No further questions, Mr. Chairman.
Okay. Are we finished with Mr. Mullen and Mr. McManus?
I am,
You
sir.
Do you hold them?
Just a couple of questions for
Okay.
Mr. McManus. Mr. McManus, just so I'm clear, when did you start at MGM? I know you said
I started in 2001, not in my current role.
Understood. And then you became general counsel in late '09, I guess.
I became acting general counsel in December of 2009, and in, I believe it was July of 2010, the acting was removed.
Let me just ask you the same question that I asked Mr. Hernandez and Mr. Murren before. Were you aware of the Times story about the wiretaps in January 2007?
I can't recall being specifically aware of the New York Times story. At some point in time, I became aware that at least the transcripts of at least some of the recordings were available. I think I, at some point, looked at them on the Smoking Gun or something like that website.
That's not where I found them, but accept that. Do you recall when did you become aware of them on the Smoking Gun or wherever it was? Was it post late 2009?
I can't remember if it was pre or post conviction. It was probably around the time of the conviction, maybe when the trial was going on. I read them.
Okay. You recall your sworn testimony in this matter, correct? I think you answered questions on July 17th, 2013. Do you recall that?
Yes.
Okay. And you testified there at the very end of your sworn testimony that you were, and I think the word you used was shocked when you saw the Wall Street Journal story that contained the suggestion that Mr. Krikorian was possibly implicated in the wiretapping.
Yes. I was shocked that that comment had been made during the trial because we had been assured otherwise.
Okay. But in your sworn testimony, at least, you say you were shocked. if I've got this correct, for two reasons. One, that the people at Glazer Weil had told you that he was not complicit. Is that one of the reasons?
Yes.
Okay. But there are fairly obvious reasons why the folks from Glazer Weil might not be the most objective on that issue, be fair to say.
Well, yeah, but they're attorneys with an obligation to tell their client accurate information.
Okay. I think the other reason you said you were shocked is because you looked online and you found Mr. Krikorian's testimony where he flatly denied being involved, correct?
I don't think that's correct. I did read Mr. Krikorian's testimony, but that's not why I was shocked by the article. I think the questions that I answered in response to Mr. Krikorian's testimony were more along the lines of, I was asked why we didn't investigate. And one of the things I said was that he had testified under oath in a criminal trial in federal court on that topic.
But, well, I'm glad you raised that, because at the point in time, shortly after the Wall Street Journal article came out, you began to, I know you weren't acting general counsel at this point, but did you have some direct involvement with the lawyers from Weil Gottschaw who were doing some of the work on this internal investigation?
I did.
Okay. And I think you testified in your sworn testimony that you had, that you or Mr. Hernandez had actually requested that they investigate the possibility of Mr. Krikorian's complicity.
I can't remember what I said during my testimony. I know that there was a discussion about investigating essentially the underlying facts.
Okay.
I can't recall.
And in your sworn testimony, you said that the response you got was, I'm pretty confident there was a conclusion, there was no real way to try to investigate that.
That's correct.
Okay. Did you, in your role with the company at that point, and I think this is the fall of '09, sometime after the Wall Street Journal article, did you push the Weil Gottschaw people to listen to the transcripts that were up on the web?
I can't recall that detail. I would be surprised if they hadn't sought that out and reviewed it.
Did you push the Weil Gottschaw people to review the transcripts, the 6.5 hours of wiretap transcripts from the trial?
Not to my recollection. And please remember, Weil Gottschaw represented the audit committee. I wasn't directing them.
Okay, understood. Do you know if there was any effort by anybody at MGM to get Weil Gottschaw to attempt to review the materials that have been generated in the civil litigation between Mrs. Krikorian and her former husband and others?
I don't recall specifically, but Weil Gottschaw was incredibly thorough, and I'd be surprised if they had not looked at anything that might have been relevant and was publicly available.
Did Weil Gottschaw ever put anything in writing to the MGM Audit Committee or Compliance Committee about this question, Mr. Krikorian's complicity?
I don't recall.
Was there any effort at this point on behalf of anybody at MGM to talk to Mr. Krikorian himself about it?
Well, Weil Gottschaw and the two regulatory law firms were conducting the investigation and conducting the interviews, and I know that somebody's interviewed Mr. Krikorian. I don't recall who or what they, I was not privy to those interviews.
Okay. No further questions.
Okay, now we've
One quick question, just building off what you were talking about with relationship to the project in Vietnam. You seemed to hint at the end there was a risk to the company for backing out of the deal.
I think there's a business and reputational risk. You don't want to, as somebody who had been announced as the project manager, to be seen by other possible developers as abandoning the project or something of that sort. That was a very real business risk that I think the regulatory risk outweighed.
I mean, it would just seem to me you're backing out for a good reason, which is your expectations weren't being met on the regulatory front. And you're kind of standing up and being a good guy and saying, I don't want to operate in that environment.
Well, we didn't make a press announcement about our reason. We just provided the owner with a notice. Probably until today, that hasn't been publicly aired, the reasons for our departure.
Sorry to do that. Okay.
It's okay.
Okay, are we we finished with Mr. Murn and Mr. McManus. Thank you very much.
Thank you.
Thank you.
You want to tee up your next witness? We'll take a quick break and I'll be right back. I think it is your turn again, sir, to introduce another witness.
Can I just pass it on to Mr. Mackey? Our next witness is Grant Bowie, who is a member of the Board of Directors and CEO of MGM China Holdings, a publicly traded company listed on the Hong Kong Stock Exchange, in which MGM Resorts International owns 50%. He is also a member of the Board of Directors of MGM Grand Paradise, the subsidiary that actually holds the gaming concession in Macau. Mr. Bowie, please give a brief explanation of MGM's operations in Macau.
Thank you, Chairman Crosby, Commissioners. Again, thank you for having us here today. If you please excuse me, it's about 2:45 in the morning for me.
Thank you for coming.
It's my great pleasure. MGM has been operational in Macau since 2007, as we've heard. We currently run one property. It consists of about 2.2 million square feet of hotel, 600 rooms. We operate 427 tables, 1,450 gaming machines, with a variety of food and beverage, other entertainment options. We are currently in the process of constructing a second property, a budget of $2.8 billion US. It commenced some 6 months ago, with a completion date anticipated to be early 2016. That property will have approximately 1,600 rooms, operating 500 tables, 2,500 slot machines, has extensive non-gaming activities, particularly in relation to entertainment, food and beverage, retail, and other aspects, particularly focused on non-gaming facilities, and I'll briefly discuss some of those issues as we move into the testimony. I think that it's pretty clear that one of the things I'd like to work through is obviously the business environment and the regulatory environment for Macau, because I think that's particularly relevant. Macau is obviously quite unique in that, as was mentioned earlier, that it is a special administrative region of the People's Republic of China. Macau, along with Hong Kong, therefore operates under what is euphemistically known as the one country, two systems. One country in that it's all part of the sovereign territory of China, but under a special arrangement for 50 years, the basic law that pre-existed in Macau will continue to operate through this transitional period. As a result of that, China sees Hong Kong and Macau in a very special way and has made significant contributions and will always positively support the interests of Macau and Hong Kong. As that applies to gaming, that in a lot of ways represents the contribution of allowing a lot freer access for their residents to come to Macau. For in China's view, Macau is part of China. And I think that's really important to appreciate the context in which that operates. The overall legal environment for Macau is also based on civil law. And under that civil law, it's a modified civil law taking into account the unique characteristics that Macau used to retain as a part of Portugal, as a colony of Portugal. And obviously was significantly influenced by Portugal's operation inside the EU, which has had impacts on how the legal system in Macau has developed over time. Recognising that Macau, though, is a very small a very small sovereign state of only 500,000 people, the legal system's primarily been based on individual ownership and partnerships, and did not really take into account the type of corporate structures that we would be familiar with. They do have corporate law, but again, it's derived from scaling up of small enterprise. On the front of the gaming regulation, gaming has been obviously legal in Macau for many, many years. It operated under a monopoly until 2002, when with the new chief executive on the return to China, the government opened up the gaming concessions to outside parties. I think it's a recognition of the strength and the character of the government of Macau that they recognised that they needed to bring other participants into the market. Not because I think it was easy, but because it was hard. They introduced gaming operators and operators of integrated resorts, which they believed would allow them to significantly modify, change and transform their economy, the opportunities for their people, but also the necessity for them to be able to be viable within a new global environment. The gaming regulation is based on concessions, unlike licences, where individuals were awarded the rights to operate multiple facilities. But it also needs to take, has experienced such significant growth that those gaming regulations have had to be modified and expanded. By bringing in the international operators, I think they knew very clearly that we would bring in those skills. But by bringing in those skills, we would probably also bring in significant enhanced oversight. And that's the environment in which we now find ourselves. As a result of that, the gaming regulations, which I think are robust and are consistent at the level of operation in most other jurisdictions, have also had to take into account the experience of the growth and development of that market specifically. And I think we'll cover some of those issues as we work through, and I'm sure there's going to be questions as we progress. Quite clearly, as a US registrant, for myself personally, I've spent 26 years working for US publicly traded corporations outside the United States. We understand absolutely the expectation of the US regulatory environment, the privilege, however, we have in operating in foreign jurisdictions, the need to be sympathetic of those foreign jurisdictions, but never, ever shirking our responsibilities and responsibilities to the compliance with the expectations of good corporate governance expected as a US listed organisation. Therefore, we obviously need to assess ourselves not just from a single jurisdictional basis, but from a multi-jurisdictional basis. That is based on the principles of risk assessment, recognising that different jurisdictions have different expectation of risk, different assessment of risk, and a different mechanism for managing risk. And it is on that basis that, since I have been with MGM, that we have built the control environment that exists in Macau. A control environment, a control system that is based on the requirements of our obligations under Macau law firstly, but also taking into account the expectations of the other registrants, for which MGM is also a participant. That balancing act is a challenge, but is not insurmountable, and is one that we're very proud to obviously be able to actively pursue. The system that we've created is not static, it's constantly evolving, constantly developing. And I will freely acknowledge, as part of the investigations for this application and for the applications in other jurisdictions, we've had identified to us things that that based on the different perceptions of significance and different evaluation of risk, we have looked to modify. And I will acknowledge the team that came out to work with us. Their questions were in depth and in detail. They took the time to understand the unique perspectives we had and the environment we had, but have raised issues which we will take on board and have taken on board, and I appreciate that involvement. And I think that, though, indicates the nature and style of our management, where we don't think we know everything. We are very responsive to the suggestions and observations that others make, because it's about continuous improvement. The importance for this hearing today has already been indicated to us, that we're trying to identify whether the practices that we deploy in Macau are responsible. From my perspective, from my professional career, I believe that we are creating a responsible and responsive control environment. That's not to say we don't have challenges. That's not to say we don't make mistakes. That's not to say that we cannot improve. But I think within the context of all of those issues that I previously raised, that we are well positioned, responsive, but most importantly, always vigilant to determine where we could improve and how we can improve. Overall, the Macau government has been very responsive to all of the initiatives that we at MGM, but also other registrants have made in terms of developing and taking on board many of the lessons we have learned. They themselves are operating a collaborative environment. However, we accept that they are the regulatory agency and we must take direction from them. And we will obviously be responsive to their expectations. We always, though, look to exceed performance. It's a simple fact that if you take the regulatory law as written as your compliance standard, that because we all make mistakes, if you fail the minimum test, then you will fail the regulatory compliance environment. And so therefore we try to adopt best practice, we try to anticipate activities. We also need to recognise that as the market continues to develop and evolve, whether by technology or by other means, we need to be prepared to modify and adapt our systems to that changing environment. I think Macau is a classic example of a market that has grown faster and more sustainably than was ever expected. I think everybody probably now appreciates that this year we will probably finish off with in the order of in excess of $40 billion US. I arrived in Macau in 2003, and at that time it was about $6 billion US. That growth alone, the scaling effect of that alone, has put a much stress on many systems, and as a result of that, we are constantly needing to adopt and adapt purely for the scale of operation. I think we've done that successfully, and I think we will continue to look to opportunities, however, to enhance, improve, and ensure more continued objective assessment of how the business operations will move forward into the future.
And in what direction is the gaming market moving in Macau?
Thank you. When we arrived in Macau, I think we all recognised that the model in Macau was, as a monopoly model, was monodimensional. It was primarily driven by gaming promoters, which I would classify as a wholesale business market where the business was being brought to Macau by outside distribution networks. As a entertainment resort operator, a gaming entertainment resort operator, clearly from our perspective, we're looking to create long-term sustainable relationships with our customers. And from that basis, we obviously needed to move into this market, accept the market as it was, but also to adopt and adapt the market to the developments that we see as being important for us to create a sustainable competitive advantage for us. As a result of that, and frankly with the support of the Macau government, and with clear indications from the central government, we are looking to diversify the market, particularly into other non-gaming and other areas. As a result of that, if you look now and you read many of the analyst reports, you'll see that the mass market is actually the critical driver of the future of Macau. It meets all of the criteria that I previously mentioned. That's really moving Macau from a wholesale distribution system to a retail distribution system where we as the retailer have direct relationships with our customers. It's more sustainable in terms of a business model. I think it's more comfortable for all of us in terms of who we deal with because we know the customers and have direct relationships with our customers. But it also needs to be put within the context that this is an evolutionary process and that we obviously have our own system of development, but at the same time we need to respect and accept the system that previously existed, and that we need to ensure that if we want to operate in that market, that we can do so successfully and safely. And so as the mass market grows, you're going to see more and more of the business move into that area. It also provides greater, frankly, opportunities of return because the mass market has a much higher margin than does the VIP junket market. That's a sensible business strategy to say you would always develop that segment which will give you the highest profitability. I hear many, many reports that talk about the scale of the VIP business, but in reality, for most of the operators in Macau, the mass market is already generating more than 50% of their EBITDA, and that is going to continue to grow. That strategically, as I indicated, is consistent with the Chinese government's expectations. It's certainly consistent with the Macau government, who have indicated to us that future gaming opportunities will be influenced by the amount of non-gaming entertainment assets that we actually generate and include in our property. Clearly, with the nature of MGM, as you saw this morning, those are characteristics which I think suit us extremely well, and we're really excited and see that opportunity. We're also, as MGM in Macau, one of the leaders in the development of the mass market. And so strategically, we see that as a really critical part of our future as we evolve.
And what are some of the challenges facing operators in Macau?
I think it's widely known that Macau has something of a very, may understate it, as a colourful history. And we heard this morning that prior to the handback, it really was quite exciting and somewhat difficult for anybody to perceive how that could evolve. I think there's other models, however, globally, where we've seen that transformation take place successfully. I think Las Vegas, while not as the same extreme, went through a very similar process, and I think it's that history that you as commissioners see as part of the history and the development of gaming in the United States. In a lot of ways, we see some of those similarities taking place in Macau. Clearly, the history is important. Now, there is a reality that in any environment where there's large amounts of money, and historically, casinos seem to have always had that perception that it may be attractive to organised crime. I think we all acknowledge that. We must acknowledge it, because if you don't acknowledge it, you will not be aware of it. If you're not aware of it, you are not going to police for it. If you're not going to police for it, then you're not going to actually create substantial and significant change. I think Macau collectively, with the support of the government and with the activities now being driven by the gaming operators, is seeing a significant transformation. And I think when Mr. Mefford speaks a little later, he'll talk about the sorts of assessments as he sees them in terms of moving forward. The critical point for us is vigilance, that these things are possible. And it's not a question that we can simply sit there and hope that it won't happen, because you have to presume it will. And that is the basis upon which we derive all of our systems and all of the processes going forward. It is clearly policy of the government that this transformation will take place. They want it to take place successfully, and they want it to take place in a way which allows Macau to take on a role as an international tourism and leisure destination. And everybody knows tourism characteristics tells you that one of the most important things for any visitor is safety. And these issues must be addressed.
Is what?
Safety.
Safety.
Of the person, the individual. Sorry, my accent. I think I'm in a minority group. So Jim gets credit. I'm not a woman, but I'm a minority. And again, those are some of the key characteristics. I think Macau has a wonderful history, which I think creates a great landscape and a great backstory. But the critical point is that the activities that we're all undertaking to take it into the 21st century, to be a vibrant, viable contributor to the overall economy of China, and recognising that China is going through a massive transformation in terms of its own rights, the own activities of its people as it converts to a consumption economy. Macau is the beneficiary of that, and that's something that I think is really important in the activities that we're undertaking.
How does MGM Macau handle AML compliance?
Okay. When something grows as fast as that does, we're now a $40 billion market, everybody starts saying, how do you manage those processes? I think the critical point is that we obviously need to develop a position of scale. I think it's important to understand that Macau has been and has had anti-money laundering legislation in place since 1998, and that was revised in 2006. They are a respondent to all of the international conventions and the international agencies. The greatest challenge, though, is that there is always this perspective of how does it work in China. For all Western organisations, it is a somewhat complex and at times opaque environment. That's not to say that there's something going wrong, it's just not clear. Therefore, we must put in place best practice principles supported by the Macau government, but also supported by the Chinese government in terms of how that works. We have obviously spent a lot of time developing our practices and processes. Firstly, they must comply with the Macau law, but also we are looking to take another standard of performance that ensures that anything we do in Macau could not or would not, firstly, embarrass or put at risk any other licences that MGM resorts may operate within. And so the AML practices that apply in Macau are fairly similar in terms of the reporting, documentation and substantiability as applies throughout the organisation. In fact, John McManus's team with support are providing support to not just ourselves but the whole company so that we have as close as possible a uniform approach to AML processes and also KYC, know your customer. In China, it is an evolving process. And one of the great challenges is the historical perception that many people didn't want to identify themselves. That in itself is moving rapidly forward, and those issues about disclosing IDs and those sort of information are becoming a thing of the past, and as a result of that, we're seeing much more effective engagement in terms of AML processes. I think it's fair to address head-on the issue about the gaming promoters and AML. It is true, and I acknowledge and I appreciate the comments made, that we have a robust system, but if there is a weakness, it's concerning the gaming promoters. I do not deny that they create unique challenges for us. They do. But we also are seeing, and by active engagement with the management of the larger gaming operators, we only operate 7 now. We lost 1.
Thank you.
We have 7 operators. There's over 200 licensed operators in Macau, but we've determined that we're comfortable working with 7 operators. We're spending a lot of time with their senior management and helping them develop their own systems of control. I'm not saying that they would not historically see this as something that is a burden, but I think they understand, because many of them are publicly traded vehicles themselves, that this is just part of transforming themselves into a larger scale, into a new format of operation. We've done considerable amount of training, we've spent a considerable amount of time with them, and we are continuing to allocate time and resources to ensuring they improve their level of performance and meet the expectations that we have for all of the people for whom we do business. We've made great strides in improving that performance, and we will continue to do so. At the senior management level of the major gaming operators, they fully understand what their legal obligation is. They fully understand that they must comply with not just our requirements, but those are the requirements of the Macau government. And they also understand that for them to be able to operate successfully into the future, they must have a much more robust system of control. We will continue to work on those processes, and we will continue to enhance their AML compliance. There is, in comparison, and to say 6 or 7 years ago, it's light years away. But I would acknowledge to the Commission, and I would acknowledge to any other party, that we need to continue to improve that area of performance. And we will do that, and we are committed to doing that into the future. I can also indicate at this point in time that the Macau government has just commenced their review of AML processes, and we have been put on notice by the Macau government authorities through the DICJ of the specific areas that they'll be looking at for specific review and comment. And that does apply to areas of ongoing compliance for the gaming promoters in terms of how they can more effectively adopt the requirements going forward.
Why don't you explain exactly what a gaming promoter is and their role in the MGM Macau operations?
Okay. Having already spoken about them, I guess I should have done that first, but it's 4 o'clock in the morning for me. A gaming promoter is, under Macau gaming law, is licensed to operate as a commission agent. That is, that they have a special position, once approved, to be able to seek customers, bring them to our property, And having brought them to our property and they play in the property, they're entitled to a commission, effectively a share of the gaming revenues. That commission is either paid as a straight percentage of loss, or it's paid as a percentage of the turnover for the business that they bring into the property. I think it's important to understand, however, that even though they act as promoters of bringing customers in, we at all times remain in control of all the gaming activities. And so the dealers, the supervision, the surveillance, the security, all of the services provided, F&B services, obviously they stay in our rooms, at all times remain under the control of ourselves. Now, I've read in the reports that it is acknowledged that the gaming promoter has a cage in each of their rooms. And it's from those cages that they actually do their transactions with their individual customers. I would also indicate, however, that we also have cages in the vicinity, and in those cages where we do transactions with the gaming promoter, those cages are always under our control and under our supervision. So that's a unique nature, unique characteristic of Macau. Having said that, it's not only operated like that in Macau. This gaming promotion principle also operates in Australia, also operates in Malaysia, and also operates in a similar way in Singapore. In Singapore, it has proven a little problematic, but they do have that capacity to operate those operators as gaming promoters.
Does MGM Macau do due diligence on its gaming promoters?
Yes, we do. There is an extensive review. Firstly, because it's something of a legacy, because I think everyone believes is an issue. Secondly, it's because we also need to understand who we're doing business, and clearly, as they are so intimately involved with our operations, we need to make sure that we're comfortable with the nature and backgrounds. It's an extensive review. It's a multi-layered review. And again, Mr. Mefford can describe a little more detail, but what's important is that we clearly are focused on identifying the individuals and the organisations that we may be doing business with. The organisations, obviously, that we contract, which are the licensed gaming promoter, have to provide us with all of their background information, their corporate histories, the background information of the principals, their financial capacity, their experience in the gaming areas to be able to deliver that business to us. And in addition to that, we obviously will be looking behind the individuals as we go forward. Again, at this point, I'd like to discuss the notion of the collaborator. The collaborators are people who obviously work with the junket operators. What's important for us is it's not just simply it's simply important to focus on what would be classified as nominated collaborators. For us, it's really important to know who's doing business in our rooms and who may be associated with. And so while we don't specifically look to individual collaborators, it's more important to us to look at the entire context and the entire structure of who's involved with each of the operators and who may be involved within those rooms. If we look to the nature of infiltration from organised crime, it's a highly probable thing that they're not going to nominate themselves, whether it be as a licensee or as a collaborator. And so for us, we don't take a structural review. We want to take a global and a holistic review to determine who we're doing business, how they're doing business. A review that is not simply determined at one point in time, but one that we understand requires continuous compliance and a continuous oversight. And over the last 3 to 4 years in particular, as the market has grown so rapidly, that process is taking more and more resources, and our company is committed to keep on adding whatever resources we need to do to make sure that we can obviously cover this off to our own satisfaction.
Does MGM Macau provide credit to gaming promoters?
We do provide credit to the gaming promoter, but I think it's really important for me to indicate that the provision of value in the nature of credit is provided through what we classify as non-negotiable chips. And I think it's in your submission, and we can discuss if there's any confusion. Why do I want to highlight that point? To me, it's actually very important for everyone to understand that the provision of a non-negotiable chip means that it has limited use. It can only be played in our property. It cannot be converted to cash. It cannot be taken out of our property and used elsewhere. It cannot be in some way transformed. It's really, in my mind, provided as a working capital float to those operators. In their context, it's effectively a way of them getting a better treasury management function within their organisation. It's a bit like us providing inventory on consignment, and as they sell it, they will pay us for that. The distinction I want to raise, because I know it's going to come up as an issue, is it is no clear connection. I'm not saying there isn't a connection, but there should not be seen as a clear connection between the non-negotiable chips that we advance to the customer and the relationship or extension of credit that a gaming promoter may have with their customer. It is also becoming extremely likely inside the gaming promoters that they're now becoming reluctant to extend credit to customers as well. And so what I would indicate is that the nature of our extension of credit to the junket operator is in of itself not reflective of the nature of the transactions that the individual gaming promoter would have with their customers. I would reiterate, that doesn't mean that the gaming promoters are not extending credit to customers, but I don't think that we should immediately jump to the conclusion that all of their business is on credit, because that is actually false. And it is understood within the marketplace of Macau that the junket operators themselves are becoming less reliant on and are more reluctant to extend credit within the market.
How prevalent is the use of cash in VIP rooms?
Cash? Cash is actually not something that we see very much in the VIP rooms, because it is true that the chip transactions take place between ourselves and the gaming promoter. They do, however, buy a lot of their chips from us with cash. So that's the extent of our relationship with cash. So our cash transactions in the gaming promoters' rooms will be the buying from us of chips. So probably in excess of 40 to 50% of the non-negotiable chips that the junket operators would acquire from us on a monthly basis would actually be acquired in cash.
What about outside the VIP rooms?
Outside the VIP rooms, clearly on our mass market, cash is the method of buying and acquiring chips, and the similar method that would apply in any other jurisdictions. They buy chips through the tables. In Macau, we do have the unique situation because of the scale that we actually sell chips through the cage as well. In those circumstances, then clearly that's all under our purview, and the critical point I suspect that we need to reinforce is wherever those transactions take place, then obviously the system in relation to cash reporting, KYC, is obviously under our control and is being exercised as we have indicated under our policies. And I acknowledge that the report that was prepared acknowledged the quality of the system that we have put in place.
No further questions.
Mr. Mackey?
I do have a few questions, Mr. Bowie. Good afternoon. And if the questions are better directed to Mr. Mefford, just let me know, because they may be.
I'll feel free. Thank you.
It strikes me that a number of the compliance challenges that you face in Macau are based on this structure that involves the gaming promoters and then the collaborators, if that's the right term. Would that be fair to say?
That's the general perception, yes.
Okay. And just so my terminology is right, so the gaming promoters are the entities that operate the VIP rooms within the casino, and then the collaborators are organizations that have sub-relationships, as if it were, with those gaming promoters and they fulfill various types of functions. Fair enough?
Yeah, that's fair.
Okay. My question is, why is the model in Macau different? Could you explain to the Commission why it is that, currently, and it may be that the share is shrinking, but currently the the lion's share of the business being done at your casino in Macau is through the gaming promoters and not done directly on a mass market basis?
I think firstly that it was a historical model that was created under the monopoly gaming operator. And I think that a lot of times custom becomes practice, or practice becomes custom. And it applied in a time when Macau was not part of China. And it was a system that evolved and developed and became a significant component of the economy of Macau. There's a lot of people who are directly employed and directly participate in the gaming with the gaming promoters. And and with the opening up and the expansion, I think that there were so many people who were part of that system that the government acknowledged and recognised that it was not possible for that system to be in some way interrupted with and interfered with, because until we had critical mass and the mass market started to emerge, that it was just not going to be feasible because of the significance it had to the individual livelihoods and the economy of Macau at that point in time.
Okay. Would it be fair to say that, and I appreciate that, there's a cultural, historical background here, but is one of the reasons why the gaming promoters play such a significant role, I think it's described in the report and in some of the studies as basically it provides the distribution network. It's the way that the customers are brought to the facility, as opposed to MGM being able to go out and advertise and market and promote mainland China itself.
I think we all understand, and we understand absolutely, that promoting gaming is illegal in China. That doesn't mean, however, that it's illegal for Chinese people to participate in gaming in Macau. That's not the case.
Okay.
But I think that given the scale of China and the nature of China, I think there is truth in what you've said, that it was part of a distribution network that was able to identify people who wanted to come to Macau to game.
Okay. And so I take it then the gaming promoters and the collaborators are able to do person-to-person type contact in a way that MGM wouldn't structurally be able to do.
See, that's where I would now say that the transformation is taking place. We have direct relationships with our customers. China, and part of its transformation to a consumption economy, allows us to communicate on a one-to-one basis. We cannot promote, but clearly if people have opted in, then we can communicate and they can communicate with us. So I think that this perception that in fact that we cannot have relationships with customers is now changing. And I think that's what we're now starting to see, is this evolutionary process as those relationships change.
And so the Commission understands the difference between communicating and promoting. Is it the difference between having a conversation and putting up a billboard or running television ads? Is that the...
You cannot publicly promote gaming in China.
Okay, publicly promote. So is that the distinction really, that the collaborators are able to do it very much on a one-to-one basis as opposed to making public advertising and promotion?
I'm not going to profess to know exactly how they go about it, but
Yeah.
clearly
I don't either.
it's about relationships. They know people, and those people may want to come to Macau to game. I don't see anything nefarious about what's taking place.
I'm not suggesting that. I'm just trying to understand why it's different.
Well, I think the critical point, if you go, that what we're now seeing is a new China. And I go back to the history of how that was. It was closed for a relatively long period of time. The Chinese government has only made statements over the last 10 years about the transformation that they wish to see their economy take, the opportunity for the transformation of consumption. And so historically, it was more difficult to communicate and identify individuals who may want to participate.
Okay. What about the ability to collect gaming debt? As I understand it, that's also not lawful in China.
That's correct. Debts are not enforceable.
And that, I think somewhere in the report it reflects the fact that MGM would not issue credit to a gaming customer who lives in a jurisdiction where you can't legally enforce the debt.
Live or does not have resources in a jurisdiction where we could enforce the debt.
Fair enough. So how are the gaming promoters able to do it, or the gaming promoters' collaborators able to enforce their debt?
I'm not specifically aware of what they do, but clearly, if there is a debt, and I think that's something that we need to also put on the table again, I think that a lot of the collaborators are working in a cash situation. I think they have resources. They do business with these people that are coming to Macau. So I'm not saying that everybody has debt. Now, I'm assuming, therefore, if they have collection mechanisms, that they would be like anywhere else. Now, I know where we're heading on this question, so I might as well confront the issue. The issue is do they use unnecessary force to collect debt? That clearly...
Well, I ask that question only because if you read the materials that are on the record and so forth, that's one of the concerns that's
Sure.
expressed by regulators here and other gaming
And frankly, I
jurisdictions.
would say to you, as a gaming operator, it's of great concern to us because it would also affect our reputation. So we are deeply concerned about what may or may not be happening in our name or by reference to our name. So I think what's really important that, and one of the things I take heart about is that I have absolutely no doubt that if this was a concern in China, then the Chinese authorities themselves would take action, because this is certainly going to have a negative impact in terms of the community within China. So I am not saying that there is not activities taking place, but I am saying that I don't think it's on the scale that people would suggest, because I think that it would create disharmony and cause concern in China, and that the Chinese authorities would take action themselves to address that issue. So that's really how we see it. But I take your point, and I think it's a very important point, and it is certainly something that we're cognizant of and that we obviously need to be concerned about.
Is it something that MGM communicates to the gaming promoters that work in its casino? Because after all, they're the ones, I understand, who have the relationship with these collaborators. But is there a message that MGM is conveying to the promoters that sets an expectation about the way that either they or their collaborators are going to enforce debts if debts become due?
We very clearly set our expectations, and the operators that we do business with are very clear, and I have, as I've indicated, to a degree are almost learning from us as they transform the nature of their own business models. And I think that's really important, that we don't just police by creating barriers or creating problems. We also spend time to transform their business operations because it's good business practice and it's improving the relationships and improving the business systems they have. These organisations, as you can expect, in a $40 billion market, are now very large, very complex, and very visible, and therefore are coming under significant external scrutiny. As I indicated, many are publicly traded in Hong Kong, and so therefore are getting a lot more visibility, and I think they're very cognizant. And I think they're also cognizant of the history and the baggage that their sector of the industry previously had. So I think they're quite aware of that.
I want to ask you very briefly about the vetting process that's done in connection with the gaming promoters who work in your casino. And again, if you're not the right person, that's fine. I read the sworn testimony of a gentleman named Vincent Trong, and is that a person that you know?
Yes, he's our
Okay.
compliance officer.
Okay, can you explain to the commission what his position is and how long this?
Well, as I think John indicated earlier, MGM Resorts has a compliance officer. In this case, Vincent is also the compliance officer for MGM China and for MGM Macau. He has a variety of responsibilities, but I think specifically to the gaming promoters, he has the responsibility for preparing and maintaining the files. He doesn't do all the investigations, and I will turn it over to Mr. Mefford to provide deeper clarity, but Vincent actually is the keeper of the record. He's also effectively the secretary to the compliance committee, and in our situation, the compliance officer reports to the general counsel, and their primary responsibility is to engage with and keep the compliance committee informed and seek their counsel and seek their input in terms of all matters associated with the investigation of, the approval with, and the continued ongoing relationship with any gaming promoter. So if you'd like, I can hand over to Larry to
That would
provide
be fine.
further.
Let me just ask a more specific question. I understood from his testimony that, at least for a period of time, but it wasn't clear whether it was still the case, that Mr. Trong was the person who was responsible for making the recommendation on the suitability of a gaming promoter to the committee, and then the committee would make the call.
I guess from his standpoint, he drafted the minute, yes. But I would say, no, he is not primarily responsible for making the recommendation.
Okay. He testified that in connection with the vetting process of the gaming promoters, that inquiries would not be made of other jurisdictions in which those gaming promoters might be licensed or not, like, such as Malaysia, for example, or some of the other Asian countries that you identified. What does MGM do in terms of communicating with these other licensing jurisdictions in Asia about the status of the gaming promoters?
I think I'd like to differentiate between making inquiries with other gaming operators to making inquiries of other gaming jurisdictions.
That's what I meant to ask, if I was unclear.
Which?
That, to what extent do you talk to other gaming jurisdictions in Asia?
You mean regulators?
Exactly.
It's actually quite difficult because most of the other gaming jurisdictions will not engage with gaming operators. So, for example, Singapore will not communicate directly with us as a gaming operator. I think they would engage directly with the Massachusetts Gaming Commission or with your department, but they would not engage with a gaming operator. However, we actively engage with all of the other gaming operators in the market because clearly we're all managing a common risk. And so that's where we would seek input. And I know that Mr. Mefford has opportunities to be able to engage, but your question was specifically what formal ability do we have to engage with other gaming jurisdictions? It's actually very limited.
Okay.
And that's legally.
But it sounds like you get your intelligence from your colleagues in the industry in Macau, for example, that operate other casinos, where the same gaming operators that work in your casino work in those casinos.
That's
Would
correct.
that be fair to say? Okay. There's reference in Mr. Trong's testimony and elsewhere to a gaming operator known as Sun City. Does
Yes.
that ring a bell? Because they're one of the...
Well, wait. The names was...
Okay. Give me 1 minute and I'll find out how much I can ask about this. Okay, let me just ask in a
Mackey.
general way, because I think I can do this without causing any issues.
Let's wait for the chairman to return.
No, we can proceed.
Oh,
He'll be-
okay.
He's be right back in just 1 second, but he said we could proceed.
I read Mr. Trong's testimony to say that in connection with the vetting of potential gaming promoters in your facility in Macau, that if there were questionable individuals who worked or associated themselves with that gaming promoter, but they were at another casino and they would not be involved in your particular casino, then their negative associations would be irrelevant to your suitability determination.
I would not say it's irrelevant, but it is difficult for us to object to them working in another operation. However, we are mindful that we need to be sensitive to the nature of those individuals and the nature of those relationships.
But the question is not whether you would object to them working in another operation. It's whether, if there are individuals that they're associating with in another casino, whether that should bear on their suitability to work in your casino.
It certainly, I would say, would be taken into account. But in some, and I understand this is a difficult line of questioning because you probably got a specific and we're not discussing specifics. But it in and of itself is simply one of the facts we take into account in terms of determining suitability or otherwise. It clearly is relevant, though. I accept that.
What about interviews of owners and principals of the gaming promoters? Again, I'm, focusing on Mr. Tronick's testimony. I know he's not here, but I read his testimony to suggest that at least to the point where a recommendation was being made to the committee, no formal interview or sworn testimony was done. Is that the case?
Can I actually turn this one to Larry?
Sure.
Because that's actually the area that he's more familiar.
Yeah, sure. The answer is, we do the interviews, but that's relatively recent, and that's part of our upgrading package that I'll explain in more detail.
Okay.
But we do interview the owners and the key members of a gaming promoter company.
I don't have further questions for Mr. Bowie. I think the remainder I should probably ask of Mr. Mefford, so I'm concluded. Thank you, Mr. Bowie.
Thank you.
Questions? Commissioners?
I had a couple of questions that I wanted to ask focused on the wholesale end of this. And I'm grateful for your testimony here, and I'm grateful for the presentations that you and another in the jurisdiction made to us on a general sense earlier. But let me see if I understand how the wholesale thing works. You have the casino, and you've got these non-negotiable chips. You have promoters who bring customers to the casino and to whom you give chips either for cash or on credit. The promoter then extends credit or takes cash from the customers that it brings to the casino in return for the non-negotiable chips. Is that right?
That's correct.
All correct up to this point?
That is correct.
And then the customer gambles and wins or loses, and if it wins, it turns in the non-negotiable chips for cash or some other kind of negotiable instrument. Is that right?
If they won,
If they win.
yeah, well, even if they win, the non-negotiables probably still would have been turned over. They would have ultimately got a cash chip, which they would then redeem.
Right.
Yes.
And that would be done at the cage that the promoter controls.
That's correct.
And ultimately, the chips in some way, non-negotiable chips in some way, make their way back to you.
Correct.
And you basically allow the promoter to run the cage where these transactions between negotiable and non-negotiable chips occur. The promoter runs that.
The promoter runs that cage.
Yeah. And you supply the VIP room, is that right?
Yes,
And you supply the gaming personnel in that room, is that right?
that's correct.
And you oversee the actual operation of the games to ensure their integrity.
That is correct.
Now, you know, at least I assume you know from reading the various reports that I've read, that many of the customers come from mainland China.
That's correct.
And it's the promoter's job to get them to Macau, the promoter and the collaborator's job to get them to Macau to gamble.
That's correct.
And you know, we all know that there are currency restrictions imposed by the PRC.
That's correct.
And those currency restrictions are about $3,000 a day and about $50,000 a year
For cash.
for cash. And we know that these VIP rooms are rooms in which much more than that is expended for gambling by many of the people who come from the PRC, right?
That's correct.
And so there is some mechanism, and this is where I'm drawing a conclusion that you can accept or reject, there is some mechanism built into this system for getting around, shall we say, the currency restrictions?
I think what's clear is that there is a system where value can be made available in Macau.
Which is to say that the currency restrictions can be circumvented.
Sir, I'm not saying that because I'm not convinced that in fact that they're moving cash. Many of these customers may have external sources of funds.
The people from the PRC may have external sources of funds.
Mm-hmm.
You, however, have, if I read the report correctly, you are aware that in some cases, there is a currency evasion mechanism that involves buying jewelry, ostensibly, right?
I am aware of that.
And for that reason, you have no jewelry facilities in your casino to prevent that mechanism.
We do not participate in that activity, that's
Right.
correct.
And what other mechanisms, if any, do you participate in to ensure that other means of evading currency restrictions are not undertaken by the customers whom the gaming promoters bring to the facility?
Your question, what other mechanisms what measures do we take to avoid?
You've removed the jewelry stores, so you don't permit the
We know.
jewelry stores in the gaming facility because you know that that may be a mechanism for evading. So my question is that's one method for
getting them
that challenge.
money in.
Right. What other methods for preventing that from occurring do you use?
It's a little difficult because we don't participate in the transactions, but what I would suggest is one of the principal activities is in fact that the financial transactions by and large are taking place in China. So no cash actually moves. And so much of the because the gaming promoters themselves have become effectively business entrepreneurs in and of their own right. They have significant business activities in China. And I think what's actually a potential mechanism is that value is provided by prospective customers in China, and that the gaming promoters themselves simply fund the gaming activity in Macau. The gaming promoter themselves obviously potentially holding assets.
With the Chinese value as collateral, in effect.
Beg your pardon?
With the Chinese property or thing of value as collateral or security.
Well, not only collateral, if they needed to, they would, it's a simple means of security, but I think potentially they're buying and selling assets with these customers. Now, this is, I'm purely speculating, but the Commissioner asked me what other mechanisms might there be available.
What other mechanisms were you using to ensure that currency evasion wasn't taking place?
Well, clearly we can only exert control within our property. And so we clearly are conscious of the need to meet our obligations, particularly in relation to AML and reporting and identifying the customers. We are not putting in mechanisms and we are not participating in any other activity, either directly or indirectly, that I'm aware of, that could be seen to be compromising the laws of China.
All right. You said that you're not certain that, in fact, there is any significant currency evasion going on. Did I hear you correctly?
I'm saying that there are other mechanisms, and that, in answer to your questions about other mechanisms, that's what I would suggest is an alternative.
The U.S.-China Commission report issued this November said that there is significant currency evasion going on. Do you disagree with that conclusion?
There is clearly significant outflows of liquidity out of China. I think that's been globally reported, and the US has been a significant recipient of some of those outflows of liquidity.
And as part of the compliance policy, then, if I understand you, you don't believe that it's necessary or appropriate to inquire into the source of the funds that the junket operators, the promoters, are having their customers produce at the casino?
The difficulty for us is we obviously don't have the relationship directly with the customer, and I'm not saying that to avoid your question. The issue is that we're provided funds for the buying of non-negotiable chips. Those funds are coming directly from the gaming operators.
Right. Now, insofar as debt collection is concerned, that's another area in which you exert no control other than talking to the promoters about good practices. Do I understand you correctly?
Yes, sir.
So that if the customer of the promoter loses a substantial amount in your casino, and that amount is backed by an extension of credit, or that amount represents an extension of credit, then whatever means the promoter uses to collect that amount back in the People's Republic is up to the promoter, and you don't concern yourself with that.
We would certainly be concerned, but the difficulty for us is that we're not aware of it. But it's certainly, we would always be concerned. And I would say to you that if a customer came to us and indicated that he was being, that the collection mechanisms were too aggressive, and frankly we have had incidents of that, then we would intercede on behalf of the customer to seek support from the Macau authorities, and they have interceded and taken action against unscrupulous activities undertaken by some sub-agents.
How often has that occurred, somebody coming to you and complaining?
It's probably this year, probably 4 or 5 times.
Okay, thank you.
Commissioner Cameron?
I was interested in the policies that were just put into effect this year. Would you know more about that, or?
Which specific policies,
I'm
ma'am?
talking about gaming promoters, AML officers, managers, and the cage staff to submit to the Macau Certificate of Non-Criminal Conviction. And in addition to that, adjusted its due diligence practices in the wake of this investigation, and now does more independent investigation to the ownership arrangements of gaming promoters. I'm talking about these recent changes. Do you have a knowledge of that, or is that
I
better
do, but
answered by?
I do, Commissioner, but I
Okay.
probably prefer, because it is actually part of Mr. Mefford's
Yeah,
presentation.
I thought so, so I'll hold my questions,
Okay.
Mr. Medford, then.
Commissioner?
Yeah, thank you. You mentioned some of these gaming promoters are publicly traded companies.
Yes, sir.
Are they, is that their main line of business, publicly, the gaming promotion?
Of that listed vehicle.
Right. I'm curious, what kind of metrics would they be measured on, similar to our stock price here? Sales to
Basically just free cash.
free
Because it's
cash?
just an income stream. They're valued basically in the form of a financial services company. Because that's effectively how they are perceived by the market in Hong Kong.
So they demonstrate assets by their
Basically,
balances
cash.
in cash
Yes.
in accounts, but
Yes.
they must recognize some kind of liability, I guess, some kind of collectibles, perhaps?
Normally, the listed vehicle is basically an income stream, because in Macau, under the Macau law, the gaming operating license at this point in time can only be held by an individual. So you can't actually list the gaming promoter license, because it's not permitted under Macau law. So what actually happens is they enter into an agreement and flow up an income stream to the listed vehicle. So effectively, it's like a financial services organisation. So they have very low debt, they have equity, and they have an income stream.
And how has their stock price been performing in the last few years?
Some of the higher performing operations have been quite well received by the retail market. Clearly, there has also been several that have failed, and by and large, they operate at a discount to the gaming concessionary companies.
Is that something you look at when you look at doing business with gaming promoters?
We obviously look at them. We see it as advantageous if they're listed, because it also means that the Hong Kong Exchange, plus all of the oversight from Hong Kong Exchange, is also exerted over those operations. And it also encourages the gaming operators themselves to develop business practices which are more consistent with ourselves.
Now, you also mentioned a handful of promoters that you do business with, 7 promoters, is that correct?
Yes, sir.
But they also in turn have many collaborators, several. Would you care to speculate just how many, give or take, each promoter has?
It's difficult to determine, but clearly they would have, as was indicated earlier, they do have some larger scale collaborators. And then they obviously, and those numbers keep changing. It's actually quite a rapidly evolving marketplace with the collaborators. My understanding is that throughout Macau, because they do have to produce a quarterly list for all collaborators in all areas, it's in the thousands of collaborators.
For each gaming promoter?
No, sorry, collectively in Macau, there's thousands of collaborators.
In the thousands.
Yeah.
I was also interested, I had a similar thought from what you were describing in terms of this transformation occurring from the wholesale to the retail, and what steps might you take, might be at your disposal to effectively eliminate the middleman, which could be at your great advantage from a profit standpoint. Go retail. What sort of efforts have you taken? Are you contemplating in your new property, for example?
Mm-hmm.
Just please expand a little bit.
I think the critical point, if you look at the large-scale resort properties that have been created in Macau, they've been designed along internationally relevant structures, where our mass floor, our main floor operation is to the fore. And it's more importantly the other facilities that we actually provide to transform Macau from just being simply for gamblers and making it more of a leisure and entertainment environment. And so the critical point for us is that we obviously invest significant amounts of time and effort into building the appeal, the entertainment, the non-gaming opportunities, and all of those other activities which encourage people to come to Macau to obviously still gamble, but also do it in an environment where they do actually partake in other activities, the intention being to increase length of stay. Those are the sorts of critical points. And if you're looking at in terms of our own marketing efforts within our own resources, that's the area that we're spending most of our time to build personal relationships with our customers. We obviously have created customer relationship programs, very similar. In fact, the M-Life program, which is operating throughout within MGM resorts in the United States, is now becoming part of the Macau operation, specifically directed to creating these relationships with individuals to expand and develop the mass market business and the relationships we have directly with those customers. And I think we'll see over time that the mass market, as I said, has already created a situation where most of the profit for the gaming concessionary companies is coming from the mass market. We're also going to see where increasingly larger proportions of the revenues will continue to come from that retail part of the market. So strategically, I think it's core to Macau, and it's certainly critical to us at MGM.
And in your remarks, you also mentioned that in that venue or in that topic, the government was going through a lot of transformation. A lot of transformation was taking place. Were you referring to the Macau government or to the Chinese government or both?
The Macau government. Under the basic law, the Chinese government does not interfere with Macau directly. So the Macau government has a responsibility to meet the needs and operate in Macau. So the regulatory environment is Macau law.
Finally, you also mentioned relative to the gaming promoters, you needed to improve, was that your oversight of the gaming promoters that you referred to? Or your relationship with the gaming promoters?
It's not so much the relationship. I think what I was intending to say, if I misspoke, the critical point is that I think we all understand the sensitivity of that piece of our business, and that we can, and we're looking to enhance and develop all facets of our business, but we understand that there is a risk there, and that we need to dedicate significant amounts of time and effort to continue to improve the overall performance in terms of compliance, transparency of that particular area.
And finally, you also mentioned that the non-negotiable chip was a key element in terms of controlling
Yes.
the environment and the activity that takes place. If you're interested in reinforcing the retail piece of your business, wouldn't limiting supply from those, cutting supply of those non-negotiable chips help in that regard?
This is a very competitive marketplace, and yes, you're right, we could take ourselves out of that piece of the market, because that's what you were really alluding to. I'm sure that there are other participants in the market who would be very happy to pick up that business. So I think the bigger issue and the more strategic focus is there is a consistent approach being taken by all of the gaming operators to move into that mass market. So I don't see it as being the initiative that one individual operator could take. It's something I think that the industry needs to progress forward collectively, and I think it's really important for the health of the industry that we all move it forward together.
Is there the equivalent of a round table at Macau that has dialogue with the Macanese government to that end?
There is a gaming association. It has had limited capacity to obviously work together. We are actually working specifically all the concessionaires at the moment on a particular issue, and we do see that as something that will potentially evolve over time, and we're hopeful that the Macau government will feel comfortable dealing collaboratively with all of the gaming concessionaires to move the business forward. So that's another area that's progressing as the marketplace matures.
Thank you.
Mr. Stebbins?
I'm all set.
I just had a couple of questions. As you move away from the wholesale model to the retail model, you take out the junket operator, how do you manage credit and collections?
So as was described through the investigation, we have a very robust process already in terms of identifying individual customers that we would think would have the ability for us to extend credit. Normally those will be customers that we've dealt with for quite some time, so they've actually built up credit history, firstly. Secondly, we clearly...
Are these necessarily non-PRC citizens?
They could still live in the PRC, but we would require that they had financial assets outside in a jurisdiction that would allow gaming debts to be enforced.
Right.
So it's quite limiting. From our perspective, clearly, we would prefer that it be that we could continue to operate on a cash basis. It's actually a much cleaner solution for all of us.
You can't really move very far, I wouldn't think, away from the wholesale model, because most of the market is people from the mainland who can't get very much money out. So there's no, is it viable to move substantially away from the wholesale model, junket model?
I think it's viable, and I will refer back to my comment about one country, two systems. I think it's really, part of the process that Macau is part of China, and that I see over time the potential for improvements in the flow of currency from China into Macau, because I think the Chinese government see Macau as China. Clearly there are regulations that control that flow, and whatever the Chinese government established, then we would need to adhere to it. I think that they would feel comfortable with because it's part of the diversification strategy, that the mass market be allowed to grow.
And then I'm not sure I understood what you said about where the lines are of the, who you are supervise and train and oversee in VIP rooms. Who do you oversee and train and supervise
So
in the private VIP rooms?
So in terms of the gaming operators, we obviously spend a considerable amount of time, particularly in the areas of AML, KYC, in terms of those staff inside the gaming rooms who are responsible for carrying out those tasks. So all of their cage staff, each of the gaming operators is required to have an AML manager or supervisor, and we spend considerable amount of time with them to improve their knowledge and understanding of their obligations under AML. So it's all of the staff that would come into...
Okay, that's what I thought you said, but there's a sentence in this report that says, the MGM Macau also does not conduct any due diligence on the gaming promoter's employees who operate the financial cages in the gaming promoter rooms, nor on the gaming promoter's anti-money laundering coordinator, also an employee of the gaming promoter.
That specifically talks to the backgrounding of the individuals. That Mr. Mefford will specifically address, as we've picked up. But within that context, when those employees, when there are people in the property who have been identified in certain positions within those gaming operators, we still provide training to all those staff.
Okay.
So there's a distinction here between background checking on the individuals, which we are now undertaking. But in addition to that, we interact with them to make sure that they have the appropriate training to be able to meet their obligations under AML, etc.
Got it.
Okay.
Anybody else? Mr. Mack?
No, sir.
Thank you.
Thank you. I'd like to call our last witness for the day, Larry Mefford, who is the Senior Vice President of Global Security of MGM Resorts. Larry, would you please start off by describing your background?
Yes, thank you. Mr. Chairman, members of the Commission, I've spent a little over 40 years in law enforcement, national security, and corporate security. I started in 1972 in state law enforcement. After spending 7 years, I joined the FBI, and I spent a little over 24 years with the FBI. And during my career, about half of it I worked criminal matters, including international organized crime and gang matters. And the other half I spent working counterterrorism and national security matters. After 9/11, I was brought back to DC and promoted as an assistant director. I worked with a team to form the FBI's first cyber division to address internet-related crime and national security-related issues. And I was promoted to run counterterrorism operations for the FBI shortly thereafter. I retired at the end of 2003 as the executive assistant director for national security for the FBI. I joined the casino industry as head of global security for another company, and after 3.5 years, I accepted a position in the same role running global security for Barclays Bank based in London. In 2010, I came back to the U.S. and I started a consulting service, and I worked with Grant in Macau. He retained my services on a part-time basis to assist with the due diligence investigations, primarily focused on the gaming promoters. Earlier this year in April, John McManus and Jim Murren hired me as the Senior Vice President for Global Security for MGM Resorts International. I've worked with Grant on and off since 2004. And obviously, we had a close and effective working relationship. And I've been associated then with MGM Resorts since 2010 to some degree.
And tell us about your responsibilities as Senior VP of Global Security.
Essentially, I oversee and coordinate our security staff at 17 properties, 16 in the U.S. and the one in Macau. That consists of about 2,000 security officers and investigators. In the U.S., obviously, we have operations in Las Vegas, in Reno, in Michigan, and in Mississippi. And we have a network essentially worldwide to support our efforts. And our focus in the U.S. is terrorism would probably be because of the, while it may be low probability in some regard, it's very high impact. So terrorism remains our #1 focus, followed by serious violent crime and other serious types of crime, organized crime, cyber crime, and the emerging threats to computers and networks. And then we play a major role in our due diligence efforts, where I have an investigative team based in Las Vegas, and I have a team based in Macau now, where we conduct background investigations of individuals that are not only that we might consider employing, but that we might consider doing business with. And in that regard, we're involved in the vetting of our junket, our gaming promoters in Macau, and some of their staff. That system has evolved over time, and we've made some recent adjustments since April. And our goal is to create a comprehensive approach to the system so we fully understand who we're doing business with. Part of this effort is to maintain very effective liaison and a very close working relationship with law enforcement throughout the world, wherever we may have business interests. That includes not only in the U.S. and obviously in Macau, Hong Kong, China, and surrounding areas. And so we work very hard at effective liaison with the regulators and law enforcement agencies. I think similar to your situation in Massachusetts, in Macau, we actually have law enforcement officers on site. They have an office on our operation, our resorts in Macau, as do the gaming regulators. So they're there on property 24/7.
And what are your specific responsibilities with respect to MGM Macau?
I work closely with their security chief, who I know very well, and I oversee their investigative component that works on the due diligence and the background investigations for employees and other people. We have a tiered approach to security, so we bring in our physical security team that operate obviously throughout the property on a 24-hour basis. We work with gaming surveillance, which is an independent entity in the company that obviously surveils our casino operations. Our investigative team is employed to work with those entities. And then we obviously work hard to maintain effective liaison with government agencies such as police and the regulators. Now in Macau, the risk assessment's a little bit different. Obviously, we're worried about terrorism, but luckily in that environment, terrorism is very low, the risk of terrorism. Serious crime, in particular violent crime, is very low. For instance, in 2012, I think in Boston you recorded 63 murders. Borrow part of your coat, please. Excuse me. I think you recorded 63 murders in Boston that year, and Macau recorded 4. You had a little over 1,900 robberies in the city of Boston, and Macau had about 163, and somewhat similar population. I think Boston is about 60,000 people larger than Macau, but it's somewhat similar. So on street crime and normal criminal activity, Macau has a very low crime rate, as does Hong Kong and as does the PRC. So the issue for us in Macau is organized crime or the triad activities, where I regard the risk as very high. And we put a lot of effort, obviously, to address that risk. And it's evolving and it's changing. I've seen in my almost 10 years experience in Macau the evolution of that process, but it still exists, and obviously it's of great concern to us. I'm in Macau personally about every 8 weeks. I'm on the phone to somebody that I work with in security in Macau almost daily, certainly in communication by email. And so we have a very close working relationship with our security team in Macau.
How experienced is your team in Macau?
They're very experienced, and we're looking to upgrade the team also. I recently brought on Jim Lyle. He was a consultant for MGM Resorts along with myself for many years. He's a very experienced retired Hong Kong police officer. He specialized in triad-related investigations, as did the head of security for MGM Macau, Mike Holomboski, who is a very experienced retired Hong Kong police official. Working with them, they have a very effective network that they've developed over those 25 years. And they have brought in a team of investigators that are comprised primarily of retired Macau police officers and Hong Kong police officials. And that team is undergoing also, soon we're going to upgrade that whole component.
And can you describe the vetting process you perform on prospective gaming promoters?
Yes. Besides the background investigation process, we have recently implemented some new changes to our system. For instance, we now interview all of the licensees during the vetting process, which we didn't do consistently prior to this. We conduct a background investigation of all of the gaming promoters, cage employees, AML employees, room manager. We get police checks with their consent with the Macau or Hong Kong government, depending on where they're from. We update the backgrounds of all of our seven gaming promoters on a yearly basis, where prior to this point, we updated those background investigations every 4 years. We've tried to improve our liaison with local law enforcement throughout the entire region, and I think we have a very good and very productive relationship with them, a two-way relationship where we can share information that's mutually beneficial for us. And we're looking right now to hire a new director of investigations in Macau, and I'm looking to hire another retired FBI agent that's very experienced in Asia, that would be based in Macau to work and report to Jim Lyle. So at a lot of levels, we're trying to improve our efforts, but essentially when we receive the tasking to conduct a background investigation on the gaming promoters, that basically focuses on the licensee, any shareholders for the company, and the financial guarantors, people that financially back the company. And it's an in-depth background. Takes at least 30 days, sometimes longer. And we check public databases that would be available to us, not only in Macau, but also in the PRC, Hong Kong. Depending on the individual, if they travel to Europe or if they've operated at all in any business capacity in the U.S., we'll check U.S. records. So one of the changes we've made is that we do a global check now, so that we can have a comprehensive report. We obviously use subscription database accounts that are available to us for international databases. We check local and regional litigation records, court records, bankruptcy records, and when with the consent of the applicant, we check credit records where available. And also with the consent, we require all of those operators' consent to obtain their criminal record checks in Macau and Hong Kong. And under the laws of that region, if the applicant consents, they can go down to the police department with one of my investigators, and with their signature and consent, the police will turn over their criminal history. And so we have access to that. Obviously, without their consent, we have difficulty obtaining that. We check international watch lists. And these are lists that contain names of people that might be politically exposed persons. They may be on terrorism watch lists. They may be on money laundering lists. These are basically warning lists that different international organizations publish. We conduct the interviews that I've referenced earlier. We have a very comprehensive program now to monitor international news media, and including PRC and local Macau and Chinese media in English, Portuguese, and in Chinese.
Do you monitor any activity in the VIP rooms?
We do. We have a program, again, I mentioned earlier that our security approach is a tiered approach. In the VIP rooms, our gaming surveillance department, which in Macau reports directly to Grant, and it's a check and balance on our security teams so that they're not controlled under one entity, so that we can basically watch each other. Gaming surveillance has a mission to look at the activities, and they watch very closely what occurs in the VIP rooms. The security team, the physical security team, is present in VIP rooms, and they observe and watch what occurs. We have an investigative team, not in uniform, and they filter throughout the resort property, and they're watching and observing. And we're looking for activity or conduct that may be indicative of organized crime, triad activity, or other illegal activity. What happens, everybody I know is focused in the area of organized crime on the VIP rooms in Macau, and frankly, that's part of the problem, but honestly, there's an equal problem if you're not careful on your main casino floor, because organized gangs will attack at a variety of levels in the casino. They'll, for example, tip hustlers is a common activity in Macau where an individual, usually in an organized gang, will sit down at a table, try to befriend a player, try to act like they're giving them advice, and if the player wins, they will ask for a tip under the premise that their advice was helpful or perhaps their presence was lucky. And oftentimes, the request turns to more of a demand if you're not careful. So your security staff has to be very attuned to that. Oftentimes, these are triad gang related, not exclusively, but they can be. We have individuals that the point pickers that will try to take the electronic cards that are used in slot machines and try to basically steal those cards and then convert them to something of value. We have thieves that are focused on obviously stealing bags and other items of value from our players. And this occurs, of course, worldwide. This is not unique to Macau. The problem in Macau is that there are organized gangs, and we have a level of gaming cheating in Macau that's obviously bears watching. So the security staff has to be trained not only in general criminal matters, and I said earlier in my comments that crime in Macau is actually very low. You can walk 24 hours a day, almost any area of Macau without any danger, and it's a very safe environment. But the organized criminal activity is what you really have to focus on. So we have to train our security staff in Macau in ways where they're focused on this organized activity so that we can stop it immediately. We know that the triad organizations in Macau, besides some of the criminal activity that I've outlined for you this afternoon, they're involved in prostitution activity, loan sharking, sometimes extortion, occasionally kidnapping, although again, it's very low by our standards proportionately to the population. They also are involved in the protection rackets where they may offer their services to protect bar owners or nightclub owners. And they provide services. They tend to be car parking services and maybe queuing services that they might offer at different public transportation areas. So you have to educate your security staff very specifically. And what we do is our strategy is not to allow these organized gangs to get a foothold on our property. And so we're constantly vigilant. And the security team ejects these individuals immediately if we detect them. We coordinate with the police constantly to take action as appropriate. But my view would be VIP room focus is one part of the strategy, but you have to focus at multiple levels.
I have no further questions.
Mr. McDowell?
Just a couple.
Yeah, Mackie?
Mr. Efforts, you talked about the vetting process for the gaming promoters. It sounds like that process has been significantly enhanced over the last 5 or 6 months. That'd be a fair statement?
Actually, when I was retained by Mr. Boy in 2010, we started looking at it, and on a part-time basis, on a specific task basis, we started upgrading back then. And we've slowly been improving it as we become better educated as to the environment.
Okay. What do you do to make sure that there are that the promoters don't have hidden ownership, hidden shareholders, associations that might not be apparent on the face of the paper that you're getting?
Right. It's a challenge at times, and frankly, it's a challenge in any business environment worldwide, not just the Macau gaming promoters, but we try to maintain an effective intelligence base, effective liaison with law enforcement, so that perhaps we can receive information. We try to, I mentioned earlier, we try to observe what's occurring in the VIP rooms to see if we can detect activity that might indicate ownership. Sometimes you can detect these types of activities just by surveillance, but it's a variety of things, and it's challenging.
Do you make any effort in the vetting process for the gaming promoters to try to figure out what collaborators they're going to work with? Do they have to give you, for example, they give you a list?
I know we receive a list on a quarterly basis, but as Mr. Bowie indicated, it's a list, my understanding, it's a list of collaborators that promoter may use Macau-wide, and so it's the list that I've seen for over 4,000 names. And so, and they change constantly, and plus the operators are very secretive about the list because they don't want competitors to steal potential collaborators that are very effective. So it's difficult at times to obtain accurate records as exactly who they're working with. But our approach is to watch what's occurring in the VIP rooms from the different levels that I've described to see if we can detect activity that we're not comfortable with.
In terms of watching what's going on in the VIP rooms, are you familiar with, well, I'm sure you are familiar with the STRs, suspicious transaction reports?
Yes.
Could you describe what those are to the commission?
Yeah, well, a suspicious cash, in a suspicious cash transaction, just like in the U.S., employees in Macau are trained, and certain employees, AML employees and cage employees will file those reports with the Macau government. Same thing with, they have an equivalent of a CTR, cash transaction report, where they file those reports with Macau government.
But I take it with respect to what goes on in the VIP rooms, the responsibility for filling out these STRs, the suspicious transaction forms, rests with the gaming promoters, correct?
Yeah, I think right inside the room, yes.
Okay. And can you just give me a couple examples of what a suspicious transaction might be that the gaming...
I think this is a little bit better suited, if I can respond, it's really not a security function.
Absolutely, whoever can answer.
Thank you. The CTRs or the Rove, the equivalent of a CTR in the U.S. is called a Rove report in Macau, and that's a form that's mechanical based on the size of a transaction. So much like in the U.S., you have a variety of personnel, primarily cage personnel, who collect that information, and then it's gathered and it's filed. With the suspicious transaction reporting, it's not as simple as there's a form in the casino or in the cage that a line-level employee will fill out. In the case of one that is generated by the MGM Macau property, that there's a committee that reviews effectively an incident report that comes back. The committee works through it and they decide on the legal requirements whether it's appropriate to file the STR. We file many of those on an annual basis. With respect to the VIP rooms, it's really a dual responsibility. MGM Macau has responsibility to still file STRs on activity that it observes within that environment, as does the promoter. And this is the area where Mr. Bowie was talking about the training that we do. Now, we file STRs from time to time on the activity that occurs within those rooms.
Okay. Can you just give me a couple examples of what would trigger the filing of a suspicious transaction report? Are there 2 or 3 kind of typical cases that result in that happening?
I mean, it could be a variety of things, but you could have a politically exposed person who you discover, that would, where you don't have an independent source of funds that you can confirm. You could have...
And is the risk there that there are state funds being used to...
Yeah, that's what typically the restrictions on politically exposed persons and the reporting requirements related to them is to help governments police that type of activity.
Okay.
I think it's important to note that it's actually illegal for Chinese government officials to be in Macau. That's the basis of the PEP.
Yeah, and PEPs are not limited to China. We would be searching for PEPs from other countries as well. Another example would be play that's in the US, you would see somebody come in and perhaps have a large buy-in for chips, and then they would play for a short period of time, experience a short loss, and then try to cash out. So, things walking with cash chips or trying to create a perception that they have gamed more than they have.
So they're, in other words, they're taking their cash, they're buying chips, and then they're just taking the chips and cashing them back.
Yeah, and that's probably a bad example in the VIP room environment with the non-negotiable chips, but that type of activity, other types of activity would include somebody who's trying to cash chips that without a record of play, things of those sorts. So it's very similar to what we do in the United States.
So how carefully, if at all, does MGM monitor the STRs that are created by the gaming promoters?
The STR specifically?
Yes.
As opposed to the rows?
Yes.
Okay. The STRs, we don't monitor specifically those filings. They have an independent obligation to file them. We train them. In addition to the training they receive from us, they also get required training directly from the DICJ. Now, more recently, in the context of this investigation, we have sent notices that we expect to be informed of these filings pursuant to our contract.
Okay. And when you say be informed, to actually get a copy of them, or?
I'd be speaking out of school. I don't recall whether we're entitled to a copy or just a notification. I just don't recall.
Okay. The, Mr. Bowie, I think you might be the best person for this, but whoever is. The DICJ, what is your overall impression of the rigor with which they apply the gaming rules and regulations to the various licensees in Macau, relative to domestic jurisdictions here?
I think they're very rigorous. As indicated, they have a permanent presence in the property. They are very particular about approvals, moving equipment, and all of the activities that we need to seek approvals for and for which they need to actively participate in. Clearly, at this point in time, for example, they're particularly focused on gaming machines because within the context of that market, that's actually new. And so we are currently implementing new regulations for the conduct of gaming machines. So their rigor is severe to the extent that some of the properties have hundreds of machines switched off because the government is no longer comfortable with the practice. So I think that they are particularly focused. I think the DICJ themselves are probably much more comfortable because of their historical context with the gaming promoters than potentially we are. But they are also very focused on AML, as I indicated earlier. They conduct their own audits. So I think they're very active. And one of the challenges that they have is resourcing, and that's a discussion that we've been having with the DICJ ourselves, is that they're struggling to get enough inspectors, and they're competing in a very aggressive labour market, the same as we are. They're looking at introducing new forms of technology which will allow them to improve and streamline the reporting processes. So I will always, in any jurisdiction I've worked in, I've always found that the gaming regulators take their role extremely seriously. They understand the responsibility. They understand that the gaming environment is only dependent on the probity and integrity of the games. And I think that the DICJ has continued to demonstrate and that they're comfortable to continue to evolve their system. And Chair, if you could indulge me for a moment, I would strongly encourage, if our application is successful, that your organisation develop a collaborative arrangement with Macau. I think it's understood that some people have found it difficult to actively engage with DICJ, and I think there's an issue there of language, of culture, and I think that it would be behoving upon all of us, particularly us as a registrant, that all of the regulators and all the jurisdictions in which we operate have a positive and constructive relationship going forward. And unfortunately, that's taken a little bit of time for some of the jurisdictions in the United States to feel comfortable with that sort of relationship, but I would strongly recommend that's positive. They're effective and they engage, and they're very mindful of the role that they play in maintaining the integrity of the games.
Just one more question. On the DICJ, what should the commission make of the statistics that are in the report about quantities of notices of violations? And in particular, from pages 62 through the next several pages, the report notes that the Nevada gaming authorities issued 17 notices of violation from 2007 to present, and in Mississippi there were 25 notices of violation letters. In Michigan there were 20, yet for that same period of time the DICJ did not issue any violation notices or take any enforcement action against the MGM Macau since the opening of the property in 2007.
In fairness, I don't think you should read anything into it, because I think it's a response to the different environments, the mechanisms that they've used. There is no question that as I've indicated, that on an active basis they are counselling with us. They don't have it within their normal enforcement practices to issue specific notices. That's not to say that they do not provide direct direction to us and provide insights into things that they find as unacceptable. And I do know that they have withheld approvals for certain actions, and that seems to be their preferred method of enforcement, and that is that they believe that holding a concession is a privilege, and if you can't respect that privilege, then they will withhold approvals for you to be able to conduct your business. So I don't think you should read anything into it. I think it is one of the characteristic differences between the different systems. And again, with collaboration, I think people understand how their systems work and how that relationship should work. So that's my experience.
Thank you.
I had a couple of questions. Mr. Meffords, is this a new position, this Senior VP of Global Security, or did someone else leave the position and you took that position?
We previously had a similar position that was eliminated several years back. There was another one of Mr. Mefford's colleagues from the FBI had held that position, and then I think it was about a 3-year period where we covered that in different ways, and then we decided it was appropriate to bring it back, and that's when we brought on Larry, having had the working relationship with him.
Okay. I read in the report here that you were brought on as a consultant in April of 2013, but I think you mentioned something about consulting since 2010?
Yes, I actually started consulting for Mr. Bowie in Macau in 2010, and I was brought on full-time with MGM Resorts in April of 13.
Okay.
So I assumed my position in April.
I see, but then later on, you took on this new title. Is that right, or was that in April as well?
No, in April.
I think that's an error in the report.
That's an error?
Yeah.
Okay. Did the decision to fill this position recently have anything to do with this investigation?
No, in fact, when the investigators were over in Macau, and even before that, when we were here in Boston in the spring for a compliance presentation, Mr. Mefford and Mr. Lyle were with us in March of this year as consultants, and we had already been in discussions to bring them both on. And I think that had started end of 12 or beginning of 13, so that we didn't reveal that, but it was an ongoing discussion at that point.
You saw the need as a company for better, these are tremendous upgrades, what Mr. Mefford's just explained. First of all, the recognition that there are issues with organized crime, and then these various steps to upgrade background investigations, to train folks, in particular security. These are all very positive steps, and I'm just wondering if you saw that need as a company?
Mi-
Or is it a result of regulators asking these questions?
No, it was not regulators asking the questions. Mr. Holubowski, who's the Vice President of Security at Macau, is the other former Hong Kong
Yes.
colleague of Jim Lyle's, had been full-time with the company for a number of years. Mr. Mefford and Mr. Lyle had been retained as consultants for a number of years and were essentially doing a lot of the same functions. And what Mr. Bowie and I had discussed a number of times was really the need to get more of their time and to have a full-time commitment from them because we thought we could use it. And obviously that has assisted us, particularly in Las Vegas, with other areas of security that needed a higher level of organization, training, and sort of standardizing of practices among our Las Vegas resorts. So that was another component for Mr. Mefford.
I see. Mr. Medford, you talked about, when you talked about criminal checks and you need the consent before you could do those.
Yes.
What's the percentage of consent? And if someone fails to consent, would you continue to work with them?
The answer is, if they're going to be an employee, it's 100%, and if they refuse, they're not hired. If they're a junket operator and they refuse, we don't work with them.
Okay. That's all I have at this time. Thank you.
Mr. McHugh?
I don't have any questions for Mr. Meffords. I had a couple for Mr. Bowie, though, which I'll hold or ask now. I thought I understood this, but I just want to make sure that I do. Is the use of non-negotiable chips required by any Macau rule, regulation, or law?
No, not specifically. It's just a mechanism that we've created.
You've
The industry
created-
created
The industry's created it. All of you
Do the same.
use it. It does, is it part of your AML strategy?
It clearly is part of the AML strategy, yes.
Because your
Prevents.
only transactions are with the junket operators,
Yes.
and you don't have to be concerned or involve yourself in the details of their transactions with their customers where money laundering may occur.
No, we would see it as part of AML because we see it as a mechanism to ensure that through the gaming activity, it reduces the opportunity for change-up and suspicious transactions. So I don't think the non-negotiable chip program is put in place in terms of AML to eliminate our role from the other customer activities. So I'm trying to differentiate between the two parts of your question, and I might be reading too much into your question.
No, I'm just asking. I mean, it's, I don't know what's in the question.
So
except
it's
search for an answer.
So the non-negotiable chip program was created under the monopoly operator as a way to simplify, to reduce the workload, to actually be able to calculate the activity on the game. So it was actually a business decision. Because if you don't, then you've actually got to put an individual at each table to record the bets. So it was a mechanism to simplify the mechanism of determining the turnover, which was the basis upon which the commission would be paid. And so it was to simplify the process of accounting.
Right, so you didn't have to have two counters at the table, one for the operator, casino operator, and one for the junket operator.
Correct.
But it does have the collateral consequence and benefit, I suppose, of keeping you out of the details of the transactions between the junket operator and the junket operator's customers.
It certainly, I'm a little bit concerned because I don't want you to think that what we do is put it in place to push away our obligation. But it does, I think, significantly improve the accountability at the table in terms of the activities that take place.
Thank you. I just want to add one point that I think is responsive to your question. If you take the example where credit has been extended by the gaming promoter to the ultimate customer, so there isn't a cash transaction occurring at the property. With the non-negotiable chips, they only receive back a cash chip. on a winning hand.
That's right.
And they retain their non-negotiable. The non-negotiables are ultimately deposited only after a loss at the table. The customer who is in, whether it's China or somewhere else, who is taking credit, makes payment back to the gaming promoter, whoever has extended credit. There wouldn't be an AML reporting obligation where there's no cash involved in the casino, and that's really irrespective of whether the chip is non-negotiable or credit is extended in some other fashion. So where you have a credit transaction, you have very different concerns than with the AML, and this goes to the movement of currency and all of the related items.
That's when a credit transaction is involved. Right. I think I understand the answer. The acollateral consequence is a separation between you and the transactions between the junket operator and the customer.
Yes.
Thank you.
I'm just after a little historical context here. I think Director Wells mentioned that China in 1999 was perhaps a pivotal point, before that year there was some activity of triads and in Macau, and then during or right after, China took strong measures to capture and execute triads. Take us to today. Could that happen again? Does China retain that sort of intelligence and ability to take measures?
I'll let Larry answer, but I would like to clarify one point. At no time did the PLA enter Macau, as you indicated in your report. I think that's quite significant. They clearly did, however, significantly increase their policing over triad and organised crime activity to improve the safety of Macau. So I'll let Larry probably carry on.
I know there's close relationship, obviously, between Macau law enforcement and PRC law enforcement. So the public security police in Macau works, obviously, a very effective liaison, exchange of information. I'm not certain that Chinese authorities would come into Macau, but certainly, if warranted, the Macau authorities would make an arrest and perhaps deliver somebody to the border. That's what happened in the mid-'90s, and I'm not sure that you could discount that today.
Mr. Stebbins?
Wow, on that happy note. You said the surveillance extends inside the gaming rooms. Does the surveillance capabilities that you have extend to the cash cage area within the VIP?
Yes, it
rooms?
does. Yes.
It does. And just to get a sense of how much resources you're putting behind keeping up with, obviously, the growth you're seeing.
Yes.
What, if, even by a percentage figure, can you tell me your budget, staff, resources are going up each year as the market continues to grow?
Well, maybe I'll refer to Mr. Boy, since I've only been to with the company since April. But so today we probably have close to, with investigators and security staff in Macau, 400 officers. And I know on the investigative side, Mr. Boy has agreed for increases just recently. And obviously, we brought Mr. Lyle on board as the Vice President of Global Security for Asia. So he oversees our investigative team in Macau and operates to support the company throughout Asia, where he has the particular expertise. And we're looking to hire a director of investigations, as I mentioned earlier. So significant increase, and we're looking for specialists that have specific experience in the areas that obviously we're interested in.
From surveillance, because those numbers didn't include surveillance. So surveillance team is in the order of 100. We, on a daily shift, would have probably, there is 25 surveillance stations available for the 427 tables, and those have we've just upgraded those again. One of the critical points is that what we're looking to do is also introduce additional technology solutions to improve the overall oversight over the property. I would reiterate that and please don't tell Larry or Mike, but we don't actually put a budget on what we need to do to protect ourselves, even though I keep telling them that. We will take the affirmative action if we see the necessity. We will add the resources. It's critical, frankly, personally to me. As the Chief Executive, I have responsible for the integrity and probity of the gaming operation, and security, surveillance, investigations and intelligence gathering is one of the primary resources that I use to anticipate issues as they emerge. We don't wait for them to happen. We want to anticipate what's happening. Hence the reason why Larry and Jim and myself and Mike have worked together for a considerable amount of time. I think one of the strengths of any organisation and a system is to be aware of the challenge, aware of the risk, and try and anticipate. We're not perfect, and we will never be perfect. Larry talked about other criminal activities. Our logic is very simple. We can't fix everybody else's place. We just want to make it more difficult for people to operate on our property, and those people who want to participate in that are lazy, by and large, and they tend to go to the soft targets. And what I want to try and ensure is that we have a tough target. We have 5,800 employees. We are responsible for keeping them safe, and we take that responsibility very seriously. And we have 25,000 customers a day. We take very seriously responsibility to give them a positive environment in which to game, in which to enjoy their leisure activity, and that's going to be critical in Macau if we're able to grow the destination. We currently have 28 million visitors. We see that growing to 40 million visitors. So that's the role that we at MGM take. We think it's a very important role, and we will deploy the resources necessary to make sure we can keep the organisation safe.
Do you need any approval to institute some of the technology advances you want to bring in?
I would always discuss that would always come through as the executive. We clearly have a budgeting process, and we talk at length at the board. The compliance committee, I would indicate to you, are very technically savvy. In fact, they're wanting us to get every piece of CSI equipment that they've ever seen on TV. But I'm saying that we have a team that are very proactive at bringing to our attention the opportunities we have to improve the performance and improve the activities.
But do the local authorities have any ability to reject or not give you approval to institute those?
To the extent of the security plan for surveillance and the implementation of cameras and the like, yes, they would. I have never had an application for enhanced security or surveillance declined or in any way questioned. I see them seeing that as a very proactive. I'd also indicate they have on-site inspectors that actually monitor our surveillance equipment. They have their own surveillance room inside our property. And they have access to all of the cameras, plus they have certain dedicated cameras available only to themselves.
Thank you.
I might, if I could, I'd just like to add that in my role as head of global security for MGM Resorts, the senior management is completely supportive of our ideas and our view on how to approach security, and they've given us recent improvements and enhancements to our budget and to our staffing. And so I find a total commitment from the company to support a very effective global security program.
Thank you.
The Chinese currency actually comes to Macau because we don't see very much. In fact, 95% of the currency that we see, in my information, at MGM Macau is Hong Kong dollars, not renminbi. So my view is that the actual transportation of Chinese currency, PRC currency, into Macau is very low.
Nothing further.
Okay, I think we are ready to adjourn. We got other folks scheduled for tomorrow,
Yeah, we still have Mr. Barletta and Mr. Gillis.
tomorrow morning.
We can do it tomorrow if they're
Oh,
still here.
I thought I had heard you say your last witness.
Well, it's
Oh,
part
this is a
of,
different, all right,
this is
okay.
the separate trust.
Well, it's about 4:45. What would we want to do? We're scheduled to be back here tomorrow.
We should finish this evening.
We should? Okay. then let's take a quick break and we'll do that. Okay, we are ready to start. We'll introduce, yeah.
Mr. Chairman, Commissioners, may I introduce Vincent Barletta, Ronald Gillis, John Bullman, and I am Owen Tarp.
Welcome.
Mr. Chairman, Mr. Barletta and Mr. Gillis were not present when you swore the witnesses in.
Okay. Would you both please stand? Do you solemnly raise your right hand? Do you solemnly swear to tell the whole truth and the whole truth, full truth, and nothing but the truth, so help you God?
Yes.
Note that they both said yes. Thank you.
In the interest of time, Mr. Chairman, we will forego presenting our video.
As good as my Mike Napoli joke.
Mr. Chairman, Commissioners, I believe that you are aware of the fact that the gentlemen sitting beside me are not owners of Blue Tarp, nor do they in any way have any control over Blue Tarp's operations. Rather, they run a successful fourth-generation construction operation, and they acquire land for development. Mr. Vincent Barletta is the head of operations. He's the CEO of Barletta Engineering and Barletta Heavy Equipment Division. Ronald Gillis is a CPA whose principal client are the Barletta entities, and John Bullman is an attorney and the general counsel for the Barletta entities. I believe that you, Mr. Chairman and Commissioners, are also aware of the fact that Rolling Hills Trust and Rolling Hills LLC, and Mr. Gillis and Mr. Woolman obtained their less than 0.5% interest, which is capped, in the revenues of any casino that might be built in Springfield, is a result of the Rolling Hills Estate Trust having entered into a option agreement with Blue Tarp, where Blue Tarp had the option to buy a great deal of land in Brimfield and part in a neighboring town from these folks and the Callahan interests. And when Blue Tarp wished to leave that location and build in Springfield, they discussed breaking the option agreement, and as a result of that, agreed that they would pay as a breakup fee a small percentage, less than 0.5% of the revenues of any operating casino going forward. It would not be unreasonable for the commission to conclude, based on the reports and investigations that were submitted, that my clients were cavalier or careless, or perhaps even misleading in the applications and in answering the questions on the applications and the waivers. My task is to try to describe for you, to recreate for you, the circumstances of time pressures and financial pressures which weighed on these men during this time period of November 21st and December 27th, when in addition to things I will describe briefly, they were sent these documents, these qualifier documents, I'll call them, by the MGM Blue Tarp folks, and asked to fill them out because they were qualifiers. First time they ever heard of the word qualifier, first time they'd ever heard they were regarded as qualifiers. But they were asked by these folks, first time it's ever rung, but they were,
Well, you know, it works.
and it would be now. But they were asked by the MGM folks to fill out these qualifier documents in that short period of time. They had never seen a qualifier document prior to this time, and they undertook to fill them out as best they could. But during this period of time, you'll hear that Mr. Ron Gillis, the CPA for the entity, the Barletta entities, was tasked with filling out, finishing, preparing all of the year, not year-end, but the fiscal year-end reports and tax reports for all of the Barletta entities, about 50 Barletta entities, and he had that work on his plate, and he had to fill out his own qualifier documents. Mr. Bullman had his qualifier documents to fill out, and he was also concerned with two huge bids that the company had received, far in excess of anything they'd ever received before, Longfellow Bridge and Whittier Bridge in New Hampshire. By far the largest construction opportunities they had ever had. So it is into this environment, Mr. Chairman, Commissioners, that the task of gathering up the information necessary to fill out these qualifier documents was introduced. And I hope that we can persuade you that it was these pressures, these time pressures, these bid preparation and later challenges to the bids that resulted in the inaccuracies and the conduct which are cited as
When
concerns.
did they receive these documents?
I'm sorry.
When did they receive these documents?
They were emailed to Mr. Bullman on Saturday by MGM, on Saturday, November 17th. Mr. Bullman does not work for the company on Mondays, so it would have been Tuesday, the following Tuesday, the 21st, that these documents were first introduced to the company.
21st of this month?
November.
Okay.
And later, as it turns out, we were required by MGM, or urged, to get them completed and back to them by November 27th.
December.
December 27th, with Thanksgiving and Christmas intervening. Now, I'd like to call Mr. Gillis as my first witness. Mr. Gillis, would you introduce yourself to the commission?
I'm a CPA. I've been a CPA since 1986. I graduated from Salem State in 1979. I got a master's from Bentley in 86.
I meant by that, sir, just tell them your name and where you live.
Ron Gillis, I live in Needham, Mass.
And you live there with your wife and 3 children?
Yes.
All right. Now, on your education,
I graduated from Salem State in 1979
right,
and had a master's degree from Bentley, an MBA from Bentley in 86.
got your MBA from Bentley?
Yes.
And did you later earn a CPA designation?
Yes,
And when was that?
right around 1986.
And did you also acquire a notary public designation?
Yes.
And when was that?
I believe in the 80s sometime.
Now, you are not an employee of the Bartlett entities, Barletta entities, is that correct?
Yes.
You have an outside accounting firm, is that correct?
I am a self-employed CPA. I have other clients besides the Barletta family.
Are you able to hear?
You ought to pull that microphone just a little closer to you,
That better?
Mr. Gillis. That's better. Thank you.
What percentage of your accountancy work would you say was for the Barletta entities?
Probably at this time, about 80%.
And would you describe with half a dozen words what the Barletta entities are involved in as a business?
There are two major construction companies, Bartlett Engineering Corp. and Bartlett Heavy Division. We have a couple of equipment companies, and then there are probably three main holding companies for real estate, and there's multiple to the tune of 30 trusts or some odd involved.
Is it fair to say that there are in excess of 50 business entities and trusts in total?
Yes.
Now, do a number of these business entities and trusts have fiscal year ends?
A few of the larger entities do, yes.
And the fiscal year end is what?
For the Bartlett Engineering Corp. and Osprey Equipment Corp., September 30th.
All right.
But for Bartlett Heavy Division has an April year end, but we do a September year end, September fiscal financial statement form. So that, a lot of the time with the auditors spent in late November, early December when the auditors are in.
So with the September year-end entities, when are you making out the audit reports and the tax reports?
Working on the audit reports starting in middle November till the end of December, and the tax returns are due December 15th for the entities with September 30th year ends.
And what professional duties are you performing in connection with these year-end entities, as well as the other Barletta entities?
I prepare the tax returns, and I oversee the audit when the year-end audit's being done, the outside CPAs.
Now, do you have any professional assistance in making out these tax returns and audits and keeping the books for the company?
We have a controller who helps with the books of the construction company. But as far as the tax returns and that kind of thing, that's on me.
So in November, mid-November of 2012, is it fair to say you were very occupied with preparing tax returns, audits, as well as your ongoing work for the Barletta entities?
Yes.
Now, I want to take you back to mid-November 2012. When did you first receive or become aware of qualifier documents, I'm going to refer to them as, which were sent by MGM?
I believe it was Thanksgiving week of 2012.
Fair to say November 21st?
In that.
That would be Tuesday?
That week, yes.
All right. And this was during this period of time that you're preparing year-end documents and tax returns and audits and so forth?
Yes.
And were some of those qualifier documents to be filled in and executed by you?
Yes.
And did you undertake to do that?
Yes.
And what was involved in filling out your own documents?
Digging through a lot of files and old paperwork for copies of deeds of houses, old tax returns, old bank statements, financial statements, investment statements, my passport, driver's license. It was pretty detailed.
Now, at this time, mid-November, December of 2012, to your knowledge, were there some two enormous bid proposals being made by the Barletta Heavy Division?
Yes.
And what were those?
The Longfellow Bridge, which I think the final bid went in on December 21st, and then Whittier, which I believe the bid was going in January. Both were in the range of $250 million.
$250 million each?
Yes.
And Whittier Bridge, that's up in New Hampshire,
It's right-
spanning the Merrimack River?
Right near Amesbury?
Yeah. Were you involved in that work in any way? The bid work?
Only if needed, usually not in the bid work, no.
Who was principally preoccupied with those two large bids?
The estimators, Mike Foley, Vincent, and John had to deal with any kind of legal documents.
Is it fair to say that Vincent Barletta was overseeing those two bid operations.
Yes.
Do you have any knowledge of what was involved on his part in overseeing those and supervising that those two bid operations?
Yes, he was dealing with the joint venture partners, He was dealing with the joint venture partners we had, as well as he had to keep working with his guys as far as pricing, making decisions, what do you do for profit, that kind of thing.
Now, you mentioned that it was approximately November 21st, a Tuesday of Thanksgiving week, that you first saw the qualifier documents sent by Blue Tarp. Is that correct?
Yes,
And included were 4 sets of qualifier documents. Timothy Barletta, Vincent Barletta, yourself, and John Bullman.
I'm not sure if 6 were there or 4 were there, but I know there was a set of them.
In addition, there are qualifier documents for Rolling Hills Estate Trust,
Rolling Hills Development LLC. And,
LLC. Thank you.
BFB Dynasty Trust.
Now, had you ever seen qualifier documents before?
No,
Had you ever been involved in the gaming industry in any way prior to this time?
no.
Is November 21st, when you saw these documents the first time, that you knew that you were considered a qualifier?
Yes,
Did you know what a qualifier was?
no.
It's the first time that you heard that Mr. Barletta or Mr. Bullman were considered qualifiers?
Yes.
Oh. Now, in light of the fact that you've got your accountancy duties and Mr. Barletta and Mr. Bullman have their legal and supervision in these bids duties, was there an agreement reached as to how you would allocate the time between and among the 3 of you to fill out Vincent Barletta's qualifier documents?
Yes.
And would you describe for the members of the commission what that agreement was?
On Vincent's application, he was responsible for getting the personal information together, which I would not have. The business information, financial information that I had, and his corporate ownership, or office, where he was an officer, where he was a trustee, that kind of thing. That was for me to gather, because I had most of that information anyway. On the legal side of it, a lot of that was on John, as far as what lawsuits were ongoing, or he had been involved with, or the company had been involved with.
Now, excuse me, how did you transmit to Mr. Vincent Barletta the personal information that he would have to provide?
At a point, I gave him a sheet listing the questions I needed answered from him. And
Talk into
I'm sorry. At a point, I gave him a list of the questions answered by him. I believe I also had given him a blank copy of the application with stickies on it for things I needed answers for.
So, did you write out these questions for Mr. Barletta?
Some of them, yes.
And some you duplicated from the qualifier documents
Correct.
and gave them to him
Yes.
to gather the personal information, correct?
Yes.
Now, this was personal information, not only for Mr. Vincent Barletta, but for members of his family and members of his extended family. Is that correct?
Yes.
And Vincent was tasked with getting that information.
Correct.
His in-laws, his outlaws, everybody, correct?
Yes. Yep.
All right. And what was your job?
To compile everything, make sure everything was put together.
All right. Now, at this point in time, did you know that Vincent Barletta would be leaving with his family for an annual vacation they took to Key West?
Yes.
They've done that for years and years. Is that
Correct.
correct? And did you come to understand when you would be required to return these completed qualifier documents to MGM?
Yes.
When was that?
I'm not sure exactly when they told us that they weren't due January 10th, they were due the 3rd, and they wanted them the 2 days after Christmas, I think.
27th of December,
I believe that was right.
2012. Now, did you receive back from Vincent Barletta some material, or the material, on personal information?
Yes.
Now, had you been asked to help Vincent Barletta fill out documents and forms and so forth in the past?
Yes.
And why is help necessary for, or helpful for Mr. Barletta to fill out forms?
Vincent's dyslexic, and I'm not sure if that's why we do it, but part of my job is filling out personal financial statements for him, because I have most of the information.
Okay.
So a lot of forms I do fill out for him.
And does Mr. Bullman also help fill out those forms in terms of legal questions that come up?
Yes.
All right. So, on December 22nd, did Mr. Barletta and his family leave for Key West?
I believe so, yes.
And the day before that, the companies had filed a bid for the Longfellow Bridge, correct?
Yes.
And on either December 21st or December 22nd, Mr. Barletta learned that he had lost the bid for Longfellow Bridge because his bid was received 8 seconds late. Isn't that correct?
Yes.
So, prior to Mr. Barletta and his family leaving,
December
22nd.
2012. So this whole discussion is about a year ago, last
Yes.
year? Okay.
Yes.
Okay,
Remember, our deadline was January 15th.
yeah, right.
So prior to December 26, 2012, when the Barletta family left for Key West on this routine vacation, did you ask Mr. Barletta to sign certain of these, all of these qualifier documents?
Yes.
And had they been completed at the point in time that you had filled them out, had asked him to sign?
The signature pages, the full document has not been completed, but the signature pages had been signed.
The full, repeat that, please?
I was still working on finalizing and compiling all the information for that final CD that I had to send overnight.
All right. But you gave the documents in whatever state of completion they were to Mr. Barletta to sign them before he left. Is that correct?
I believe so.
And there are initials on each page of these documents. Did you put those initials on?
Yes.
Did you ask Mr. Barletta for his authority for you to initial these documents prior to his leaving?
I'm not sure if I asked before or after he left, but I did ask him.
Had you been authorized by Vincent Barletta in the past over the, how many years have you worked for the company?
25.
Yeah, but Vincent Barletta's only been the CEO for how many years?
17 maybe, something like that in that
17.
range.
And over that 17-year period, have you signed, been authorized to sign Vincent Barletta's signature to documents
Yes.
and to initial documents?
Yes.
All right. Now, Mr. Barletta and his family have left for Key West. Is Mr. Bullman around, or is he gone as well?
I'm not sure exactly when he left, but he was Christmas week. He was gone. I'm not sure what day he's gone.
Okay. He leaves for New Hampshire on a big Christmas vacation, correct?
Correct.
So he's gone. So you're by yourself in the office, is that correct?
For the most part, yes.
All right. Now, we're approaching December 27th, 2012. You've completed the documents, correct?
I went through and compiled them on the 26th, I believe. I was compiling through to finalize everything to get everything together, get it so I could put it on the CD.
And did you operate the computer to fill out these documents?
Some of them, yes.
And did you come upon, or did you examine these documents to see whether they were all signed?
Yes.
And what did you see then?
I found the waiver of liability hadn't been signed.
By Mr. Barletta?
Yes.
You had initialed it, correct?
I'm not sure if it needed initial. I think
I
it needed
see.
a signature.
Had not been signed. What did you do then?
Something that I shouldn't have done. Sorry, something I shouldn't have done. I signed his name and notarized it.
Well, did you consider that you were under time constraints?
Yes, I wasn't sure how that was going to affect everything, because I know I had to get it onto a CD and get it shipped to, I'm not sure where I had to ship it to, whether it was New Jersey or whether it was in Boston.
And you were up to the last day to do that, correct?
Correct.
Did you determine whether you, in your own mind, whether you had time to send these unsigned document down to Vincent Barletta in Key West and get it back and still make that deadline?
I didn't think we had the time.
All right. So, did you in your own mind consider that had Vincent Barletta been by your side, that he would have authorized you to sign his signature?
Yes.
Now, what did you do next after you had signed Mr. Barletta's signature?
I notarized it.
You notarized it.
Correct.
And why did you do that?
Because the form required it.
I'm sorry?
The form required it.
All right. How long, and you'd been a notary for some significant period of time, is that correct?
Yes.
All right. Now, a couple of more questions. When you were filling out the qualifier documents of Vincent Barletta, did you check, there was a question, I think it's question 28, I may be wrong, but did you notice a question that asked whether Vincent Barletta had graduated from college?
Yes.
And had Mr. Barletta given you information on that to answer that particular question?
No.
Did you answer it?
Yes.
Did, in answering it, did you check yes?
Yes.
Did you assume that Mr., strike that. You knew that Mr. Barletta had attended Northeastern University for 5 years, is that correct?
Yes.
And indeed, you were working for the company when he went to Northeastern, right?
Yes. Correct.
And did you, when you were filling out these documents, did you assume that Vincent had graduated from Northeastern University in the 5 years he attended it?
Yes.
Had you ever heard Mr. Barletta in your presence say that he attended Northeastern University?
Yes, he had talked about going to classes there and school there.
Did you ever hear him say that he had graduated from Northeastern?
Don't know if I have. I don't think so.
Now, there was another question on the, and I think this is the question 28, on the forms that asked whether Mr. Barletta's license, I think it was, had ever been suspended.
Yes.
Did you see that question on the form? It was on your form as well, wasn't it?
Yes, it was.
And did Mr. Barletta leave you with information on these papers that that gave you the answer to that, whether his license had ever been suspended?
When he gave me the forms back, he hadn't written anything on that question.
Did you have access to any database for the Registry of Motor Vehicles or any CORI information to determine whether Mr. Barletta's license had ever been suspended?
No.
So did you answer that question, no? It had not been suspended?
I believe I entered it had not been suspended.
And on what basis did you answer that?
I've known him for the past 17 years since he's been in the company. I never knew his license to be suspended.
All right. That's all I have.
Thank you. Mr. Mackey? No, it's all right.
Thank you, Mr. Chairman.
Your name?
Mr. Gillis, thank you for being here. One quick question. I just want to confirm, you testified earlier that when you had notarized and signed Mr. Barletta's form, is that correct?
Yes.
And you also testified that you believe that that action was inappropriate in hindsight. You believe that was inappropriate?
Yes.
Okay, thank you. No further questions for Mr. Gillis.
Commissioners?
A couple of questions. Mr. Gillis, wouldn't it have taken a simple phone call to verify information from the form, rather than you just assuming the answers?
In hindsight, yes, it was the day after Christmas. I was stressed. My wife was angry at me because I wasn't up in Maine with her and the family. So I'm not sure if that shaded anything or not. I'm not really sure.
Had you ever, as a notary, signed a form and notarized it with two different names?
No.
With a forged name, you mean?
It wasn't forged.
It was, okay, so this was the first time you had used the notary for that purpose? Is that
Yes.
correct?
Correct. And I don't really notarize much anymore.
Okay, thank you.
Oh.
I have no questions. I note that Mr. Todd and I were colleagues on the Superior Court for a number of years, and it's always a pleasure to hear somebody who's good at direct examination.
I thought you were ashamed to bring that up,
Right,
that we
yeah.
had served together.
I have no question.
Commissioner?
No question.
Why did you get these documents so late?
If I may, Commissioner?
Whoever knows.
I'm John Bowman, I'm counsel for Barletta, and I was dealing with Jackie Crum, who was counsel at MGM. I have no idea why. We had received no information about even a determination of qualifiers. Quite honestly, we're a little surprised that we were even considered qualifiers since we had ended our business relationship and this was a breakup. I realized we had discussions when they were going to build a casino in Brimfield about the potentially if you get a percentage, but I don't know why we didn't get them till the end of November. I have no answer for that. That's when they were forwarded. I have the email from Jackie Crum, and that's the first we saw of them, the first we heard of being qualifiers.
And do you, Director Wells, remember when it was determined that they were going to be qualifiers and with whom?
I don't know. I think scope of licensing was done before I started, so.
Which would have been,
Yeah, so I can't answer that question.
do I see.
I can do it.
Be brief.
I'll try to get to a microphone. I know we had, it was after the IAGA conference in Singapore, which was the very end of October of last year. I know that a week or two later, maybe Ted was there, I don't know. There was a meeting to talk about who would be the qualifiers. So I would say probably right around the first part of November, later, mid-November. Oh, the letter came later? Okay. I guess I'm being told the official letter came later.
The official qualifier letter saying
Yeah.
who's going to be qualifiers.
I know our board was also very upset with me for the amount of time they had to complete these, so it was rushed.
Yes,
And
sir.
if I may, Commissioner,
Chairman.
Mr. Chairman, I'm sorry.
All right.
I've never, until I was actually on the commission's website last week, I had never seen the list of qualifiers for Blue Tarp, but we never received a letter. And again, you know, we've never completed any forms like this before, so we don't have a database that has every trust that everybody's a trustee of, or every lawsuit that we've been involved in for 20 years. So putting together the information was onerous, at least for us, because it's not something typical for us in our industry. We usually keep a record of, for pre-qualification purposes, maybe 5 years worth of legal involvement, that kind of thing.
Can you, would they have been qualifiers? And by what, on what criteria were they qualifiers?
They were qualifiers because they're going to make millions, you know, the trust is going to make millions in perpetuity, so there's significant involvement. Now,
But how is that different from, say, a passive 5.3%
well,
investor?
you know, under 205 CMR 116, the commission at sole discretion can require anyone to be a qualifier. And although I wasn't there at the scope of licensing, my understanding is it was this interest in perpetuity and the local element and the fact that it was a trust, and there was, and you know, Mr. Grove may be able to comment further on that. But there's also, you know, a remedy if someone disputes it being a qualifier, but it's done at the time of scope of licensing. At this point, to bring it up, I think is really too late, especially where there's an issue with the qualifier.
To bring up whether they should be qualifiers?
Right.
Yeah, no, I'm just trying to get a context here as to,
Yeah.
you know, what's fair here.
Yeah, it's the amount of money that a local partner was going to get, I would say. Mr. Grove, would like to comment?
If I may, I wasn't involved in the scope of licensing. Stephen Ingus from our office had been the point person on that. But Director Wells is correct. Because of the in perpetuity revenue stream from gaming, I understand that is the reason why they were deemed qualifiers.
Okay.
May I call my next witness?
Sure.
John Bullman. Would you identify yourself, please?
Members of the commission, my name is John Bowman. I'm an attorney I live in Situate, Massachusetts.
And you live in Situate with your wife and your children?
3 children, yes.
3 children. Would you give your educational background, please?
I went to Bentley College and graduated in June of 1981. I went to Suffolk University at night and graduated in May of 1986.
And in addition to being an attorney, are you also a CPA?
I passed the November 1981 CPA exam and practiced as a CPA until probably the mid-90s. I let my qualification expire. I primarily became, Mr. Gillis came to Barletta sometime in the late 1980s, so I didn't need to maintain that certificate, so I let it expire.
Now, were you general counsel to the Barletta entities?
I am, but I am not an employee. I'm a self-employed attorney.
And the entities include 50 companies and trusts?
Generally, we have 2 large construction entities, and we have a lot of single-purpose entity trusts that hold individual pieces of real estate and individual businesses, so it becomes a large number of separate entities.
Would you describe, just very briefly, what the companies do?
Barletta Engineering Corporation and Barletta Heavy Division, Inc. are heavy civil highway, airport, Deer Island Treatment Plant, bridge contractors. Whirlwind Capital LLC is a real estate development entity that owns multiple pieces of real estate. Rolling Hills Development LLC is actually a spin-off from Whirlwind that primarily owns 1,500 to 2,000 acres in Palmer and Brimfield off the Mass Pike that I actually purchased at auction in the mid-90s. And those are the major entities, so the trusts are usually underneath those entities, and they're usually specific to a property. There's one for a University Ave property. There's a trust for almost every building or separate property we own.
Now, do you describe briefly what your duties are for the Barletta companies?
General day-to-day, I'm in charge of all the real estate development, most of the outside entities, and then I become involved in the construction. I deal with subcontractors if they want to modify our standard form. I deal with assembling bids when they have questions as far as I put together the joint venture agreements, some of the votes that are required. I also deal with bid protests when we have a problem with a bid. So most of my bidding involvement is probably post-bid if there's an issue, or pre-bid with joint venture agreements. I handle everything outside for the Barletta individuals. I'm a trustee of Vincent's father's family trust, who passed away in 1997, January 98. So I handle everything, a lot of things for Vincent's mother and the brothers and sisters as far as legal goes.
Do you negotiate and draft contracts?
Yes.
Now, and if there's litigation, are you involved in the litigation?
I'm generally not what I consider a litigator. I usually select outside counsel unless it's a very small matter and it can't be settled. So I more manage outside counsel as far as litigation goes.
Now, Rolling Hills Estates Trust has a contractual right to a small percentage of the revenues of any casino built in Springfield with a cap at $3 million, I think. Is that correct?
Yes.
Did you negotiate that contract?
I did. Originally I believe it was in November of 2011, we signed a letter of intent with MGM after going back and forth quite a while in terms. In January of, I believe it was 2012, we signed a formal option agreement regarding our property in Springfield, Massachusetts, that involved a purchase of the property and a payment of an annual royalty. Sometime after that point, and that contract had certain exclusivity provisions, meaning we couldn't talk to anybody else about our property, nor could MGM go someplace else. At some point, MGM became interested and thought Springfield was a better location for their development, so we had to come to terms on a breakup, and quite honestly, the breakup agreement, there's not a lot of magic to it. I almost took, there was no more property purchase, so all those dollars went away, and I basically took almost one half of what we were going to receive as a royalty payment and a success fee, and negotiated that as what we would receive as the breakup fee. So it's roughly 0.2% of the revenue, less than 0.2% of the revenue for the first 500 million, and then I believe it's 0.25% of the revenue over 500 million. And it has a $1.5 and a $3 million annual flooring cap, and that goes to the trust, which is then 50% Callahan, 50% Barletta. So our share of it was, less than 0.2% on the first 500, and a little over 0.2% on the over 500.
Mr. Chairman, I'd like to discuss the relationship between the trust and the LLC at this point. I think it'd be helpful if I provided you with a chart. May I do that? May I approach?
Sure.
You need a copy?
No, I think I could probably tell you what it says.
Want one back?
You have 3.
Would you explain now, briefly, the chart I've handed out to the members of the commission and council?
Certainly. As I referenced earlier, and I believe it was probably the fall of 1994, I went to an auction in the woods in Palmer, Massachusetts for approximately 1,250 to 1,500 acres of property. It was actually Vincent Barletta's father who had sent me out. He had known of the property. It was in foreclosure. And I was the successful bidder on behalf of the Barletta Company, Inc., to buy that property. Shortly after that, when I came back to the office, Mr. Barletta, the father, called Charlie Callahan, who we knew from Palmer Paving, and basically said, Charlie, do you want to be partners with me on this property? They agreed. We formed Rolling Hills Estates Realty Trust and the joint venture to own that property. One half of the property is owned by the Callahan Group, and one half of the property is owned by the Barletta Group. It was originally the Barletta Company, Inc., which was Vincent's father's predecessor company. The Barletta Company, Inc. transferred that interest to Whirlwind Capital LLC shortly after we settled up Mr. Barletta's estate. And then to further move it to a single-purpose entity, it was moved into Rolling Hills Development LLC. In 2006, 51% interest owned by Vincent F. Barletta was transferred for estate planning purposes to a dynasty trust, of which his wife and children are the beneficiaries and a disinterested third party is a trustee. 19% is owned by Timothy J. Barletta, his brother. 15% is owned by Mr. Gillis and myself, which is part of our, I would say, retirement plan. And then no 0% is owned by Vincent Barletta as an individual. It's all in the Dynasty Trust for his wife and children.
And it's recited that Mr. Callahan and Vincent Barletta are trustees of the nominee trust. Is that correct?
That is correct.
And down in the Rolling Hills Development LLC, the managing members, yourself, Mr. Gillis, and Mr. Barletta, correct?
That is correct.
Now, I think you've made the point, but I'd love to make it again. Mr. Vincent F. Barletta is not a trustee nor owner in the Dynasty Trust that owns 51% of the 50% of this revenue stream. Is that correct?
It's correct, and it was also, it was something that was done in 2006, long before this application or any contact with MGM occurred. It's an estate plan. The Dynasty Trust is an estate planning vehicle.
And indeed, in a Dynasty Trust, which is a tax-defined entity, the donor cannot be a trustee or a beneficiary. Isn't that the case?
My belief is that unless you go to another jurisdiction in Massachusetts, the donor can neither be a trustee or a beneficiary, or it defeats the trust. You can go to New Hampshire. Some other jurisdictions do recognize Dynasty Trusts. I mean, Mr. Gillis and I actually set up Dynasty Trusts subsequently. There are New Hampshire vehicles that do allow you to do that.
I just want to go back to this, when we received these qualifier documents. Would you pin that down for us, please?
I went back and looked prior. I'm sorry.
I think we know when you got the documents.
I'm sorry?
I think we know when you got the documents. I'm not sure we need to keep establishing that.
Okay, 21st of November.
Got it.
Just before Thanksgiving, 2 days.
Just before Thanksgiving, not all that,
In 2012.
not all that distant
And
from
Mr. Barletta
Christmas.
was on vacation. Is there anything else?
Oh, yes. Were you on vacation?
I left New Hampshire sometime before Christmas. My family goes far up, and sorry, there's no phones, no internet. It's lovely. And the only thing I will say that transpired during that period is, originally I believe we thought the documents were going to be due January 10th, but I think something in Springfield that was involved, their application process required they be in Springfield on January 3rd, which is why Mr. Nozel requested them by December 27th. So I think it was independent of this commission's due dates. It was something to do with Springfield that they wanted to be complete by January 3rd.
Now, I've asked this question of Mr. Gillis, but have you, in the past, helped fill out forms that are directed to Vincent Barletta?
Yes, but it's because most of the information, like the financial information resides with Ron in his files. The legal information and who's trustee of what, a lot of it's in my files. I mean, it's not even in Vincent's world. So we compiled Timothy's, mine, Vincent's, Ron's, because we tend to be involved in a lot of the same trusts and trusteeships, and Ron and I helped each other make sure those matrices with all the listings of officers were as complete as we could make them. I particularly do the lawsuits, but I also was involved in the schedules of who's an officer, who's a trustee of what property we own, that kind of thing.
And does Vincent Barletta's dyslexia play any part in that assignment of roles?
You know what, I'm aware that Vincent's dyslexic. I'm aware that it makes him read slower. he's very intelligent. I don't know the extent to which, it's still, the information resides with me or Ron. It doesn't really even reside in his world, and it's information that no other Barletta employee has.
Now, just a quick question with respect to the two bids. Longfellow Bridge, Whittier Bridge. Were you involved in those controversies?
I was involved in the joint ventures. I was on December 21st, the Whittier Bridge, you push a button, the Longfellow Bridge, I'm sorry, you push a button to submit the bid. It's a new thing versus driving them in and hand it to the window. It was actually 1 minute and 8 seconds late. We hired consultants, everybody in the world, to try and check the clocks between our computer, and unfortunately for us, we lost a $250 million job that we were low bidder on because it was 1 minute and 8. But that was a very rushed process during that period to see if we could find a reason why our bid should be accepted.
Lastly, Mr. Chairman, members of the commission, there, in the reports filed with respect to my clients in Rolling Hills, there's a discussion of a lawsuit that resided in the Federal District Court in Maryland. I think that was Clear Ventures versus New England.
North American Ship Recycling.
North American Ship Recycling and so forth. And Mr. Bullman can explain that lawsuit, but the reports contain the most very unflattering, very unfair descriptions of what that lawsuit was about, tossing around words like RICO violations and fraud and so forth. And Mr. Bullman can testify it was a collection case on a disputed right to extras that Clear Venture had claimed under a subcontractor between them. If that's a concern to any commissioner, I would like to go into that.
Anybody want to hear about it?
Why don't
Well, I didn't identify it as an issue for the commission, if that's helpful.
Yeah.
All right, that is very
Well,
helpful.
it's in a passing reference in Mr. Bowman's,
Right.
Mr. Bowman's
Right.
summary conclusion.
Right.
But,
I just didn't want it lurking in somebody's mind and not get addressed, but
no lurking.
No lurking.
no lurking. Well, that's it. Thank you. Mr. Barletta.
Well, let's see if we have any more questions. Counselor?
Thank you. A few very quick questions for you, Mr. Bowman. First, on the chart that was presented by council, on the bottom left-hand corner, it notes Vincent Barletta is a settlor but not a beneficiary. Vincent Barletta's wife and 4 minor children are the beneficiaries. Can you, and that's linked to the VFB Dynasty Trust. Is that information accurate to the best of your knowledge?
Yes, it is.
Okay, thank you. Mr. Bowman, were you present at the sworn testimony of Mr. Barletta?
I believe I was.
Okay. And there's a statement in the sworn testimony. There's a question from Detective Lieutenant Connors. It states, and on the document, the letter that your attorney had filed today that indicated some changes to the original application specifically regarding your education. If you could just flip to that page. So he was referencing corrections to sworn testimony.
Look at something.
No, sorry, that's the question. He had asked you to flip to a page at that point. Do you recall submitting a letter correcting any information on the day of the sworn testimony?
I recall submitting a letter correcting a spelling of Northeastern University and still indicating that Mr. Barletta had graduated from Northeastern University. And I believe I even received a subsequent phone call from, and it wasn't Mr. Grove, I dealt with someone else at Spectrum, John.
Mr. Bowman?
I'm sorry.
Was it Mr. Bowman you dealt with?
Probably. I'm sorry, it's all up there somewhere, but, and again, to my knowledge, I thought Mr. Barletta had graduated from Northeastern University.
Mr. Bowman, do you recall roughly when the sworn interview was taken?
June of 2013, sometime in that timeframe, somewhere?
I can just state for the record that the testimony was July 2013.
Okay.
So Between when the application was submitted and when you resubmitted the corrected form, did you have an opportunity to discuss the application with Mr. Barletta?
I was there, so I believe the way it went is we had an original interview, and the sworn testimony was at maybe a second appearance before the, before IEB. I'm sure I discussed the items with Mr. Barletta. I can't specifically say that, you know, I said, did you graduate from Northeastern University? It didn't come up. I'm trying to think of the context. I knew it was a misspelling. I think I was, I don't know if I was fixing other things at the same time.
Do you recall anything else that was fixed in that submission?
You know what? I thought there was more than that schedule, but I don't have it before me, so I don't know.
But it's fair to say that the fact of graduation was not something that was corrected on that.
It was not. As a matter of fact, I know I corrected the spelling because I know it's spelled wrong, but I know I still listed him as graduate, and I remember the call from Mr. Bowman saying, is that correct? But when there was a subsequent email from Mr. Bowman where he asked me about that again, and it was after the sworn testimony. I said, I believe Mr. Barlett has already testified that he did not graduate, and that was incorrect. So I said I defer to his testimony.
Okay, thank you. And with respect to the statement Mr. Todd referred to earlier regarding the suspension of the license, was that something that was corrected in that letter?
When we left one of the interviews, and I'm not sure whether it was the first and the second, I was going to correct a great deal of information. I received an email from John at Spectrum saying not to do anything about resubmitting it until I heard from Detective Lieutenant Connors. You know, and because I intended to actually, and it may have actually been after the sworn testimony, but I intended to go correct a myriad of things, and I was told not to do anything until IEB told me what to do.
Okay, thank you.
These myriad of things that you were itching to correct, they were misunderstandings by the investigators with respect to holdings and ownership of various entities. Isn't that correct?
Well, I think I was going to correct his driving record because I think we identified that he had in fact had his license suspended. I think I was, at that point, I don't know what else, there were some other things that were incorrect. I don't remember what they were.
Thank you.
Anything further?
Not from Mr. Bowman, no.
All right. Commissioners, any questions?
I think the chair has a question.
The chair has
Deferred to you.
deferred to me to the commission at the moment. And will rejoin us just as soon as he can, but in the meantime, we'll proceed. Do you have another witness?
Yes, but just this counsel behind me advised me that the commission may not be clear on when the bid was due back, that actually it was not January 13th.
Springfield applications were due earlier than the rest of the applications.
Right. Okay.
And I believe that's what I testified. My recollection is Springfield was January 3rd, where the commission was a later date.
The point that significant time pressures were involved has been made crystal clear.
Thank you. Mr. Barletta, should we wait?
No.
Oh, God, I don't believe it. Twice.
So it's now worked twice, so I think you've got a good product, Mr.
If
Todd.
I may, Mr. McHugh, if we were in a courtroom, you would have that phone right now.
I would be in jail.
Yes, yeah. But we're not, happily. It's just a conversation among
But my
interested
wife
parties.
complains that, what's the point of calling you? You never have it on.
Right.
And I don't know why it's on. All right.
Go ahead.
Vincent Barletta. Vincent, how many courses short were you from graduation from Northeastern University?
approximately a semester or two.
Two courses, did you say?
No, a semester or two, I can't recall.
And did something come up in your life that required you to leave Northeastern and work?
Well, I had started working, and during that time, I was trying to finish up, and shortly thereafter, my father became sick, and within a year or two, I was back in the family business, and never made time.
But you attended the school for 5 years?
I did.
Off and on? Or?
Correct.
All right. With respect to the issue of suspension of licenses, these occurred, your problems with traffic officials occurred as far back as 19 years ago, isn't that correct?
Approximately, yes.
1997 was the first suspension?
Correct.
What was that for?
I believe it was due to speeding offenses.
And the second suspension, when, was that the year later?
Approximately.
And what was that suspension for?
Once again,
Was it abandoning a car or some such thing as that?
perhaps, yes.
What was that all about?
Just leaving a car on the street where I lived in Watertown, and it was towed.
Where you're not allowed to park?
Yes, correct.
And you got your license suspended for that?
I believe so.
Okay. When you had your first deposition taken, could you remember those suspensions?
I remember the one along the Mass Pike in '97, but the ones after that, no, I couldn't.
And my last question to you is, when you left for Florida with your family in December 22nd of 2012, did you believe you had signed all the documents necessary?
Correct.
When did you learn for the first time that you had missed one?
At the interview with the investigators.
Is that the second interview or the first interview?
I believe it was the first one.
That's all I have.
Mr. Barletta, for the sake of time, I won't ask you to describe the process for filling out the applications, but what I will ask is whether you think Mr. Gillis's testimony regarding that process accurately describes it.
Yes.
And during your sworn testimony, I believe you testified that the information regarding your graduation from Northeastern was incorrect. Is that
Correct.
true? Correct as in it was
Incorrect.
Yeah, okay. I'll try not to use those two words at all. And you also testified at your sworn testimony that the information regarding your license suspension was incorrect.
That's right.
And would you say that, and you, can you explain the reason why those were incorrect in your opinion? Just briefly.
Why those two items were what?
Were incorrect, I'm sorry, in your opinion.
Well, in early December, I was compiling personal information, family, bank accounts, and quite honestly, I didn't get to it. When I did leave for break, I thought there was going to be time afterwards. I think when Mr. Gillis realized there wasn't, some of those holes were filled in inaccurately. Because I didn't give him the information when I should have.
And is it your testimony that you didn't have a chance to review the application again before it was submitted?
Well, I went through collecting as much of that personal information as I could, and those were two areas I didn't get to.
If I could turn your attention to Exhibit 9 of the Bureau's exhibits.
Okay.
I have it somewhere.
I think Mr. Nozel has it.
Yes.
And Mr. Berli, do you recognize Exhibit 9?
I believe it's from the website for a company called Carletta that's trying to permit renewable power.
And what is your relationship to Carletta?
I'm an investor.
Okay. And do you see on Exhibit 9, it states Directors and Management, and there's a name Vincent Barletta there. I assume that's you?
Correct.
Okay. Do you recall providing information for this website?
No, I do not.
Do you see in the last paragraph under your name, it states, Mr. Barletta holds a bachelor's degree in management from Northeastern University?
Correct.
Do you know where that information came from?
No, I do not.
Time's up.
Mr. Barletta, on the two forms that were discussed here, sworn testimony, the multi-jurisdiction form and the Massachusetts supplement, there was a statement of truth attached to each form, correct?
Correct.
And do you remember signing that form?
I remember signing a number of signature pages, yes.
And this is included within Exhibit 8, which are excerpts of your application. The statement of truth lists in it 5 different things that you're swearing to. The first, I don't know if you have it in front of you, Mr. Gills can help you find that.
Yes.
The second item here says, I personally supply the information contained in this form. And so is it your testimony today that that is not accurate?
Yes.
And the 5th statement is, I swear that the foregoing statements made by me are true. Is that statement accurate? Did you, excuse me, strike that. Do you believe that all the statements in your application were true?
At the time of signing this?
Yes.
Yes.
At the time you signed it, was the application complete?
No.
Okay, and do you believe all these statements to be true now?
No.
Okay, thank you. I have nothing further.
All right, commissioners?
Just a couple of questions. So you filled out a portion of your application, Mr. Barletta, is that correct?
Correct.
And it's your statement that you did not get to the yes or no answers, do I have a degree or has my license ever been suspended?
Correct.
May I just correct that? Mr. Barletta didn't fill out the application. He provided on a handwritten piece of paper answers to the personal questions. It had to be filled in by a computer, which he doesn't operate. Mr. Gillis handled the computer.
But he had the time to answer many questions, but did not have the time to answer 2 questions, yes or no. That's your statement.
Yes.
That's all I have.
Commissioners?
Is there, I'm just wondering, is there a sense or awareness of why the complete accuracy in filling out these documents is important to the commission's work? Is there an understanding of that on behalf of your clients?
Believe me, there is, yes, indeed. I think a lot of it is that they had no idea what qualifying documents are or why they were being asked to fill them out, had no idea what they were being required to do, and undertook to do it with the best they could under the circumstances.
If I may, you know, we took the documents quite seriously. I mean, the number of hours that we pulled away from, and as we all do, we have regular things we have to do, and this was an over and above, and Ron and I spent nights and extra time, and the schedules to complete all the holdings and the lawsuits and the research to get the data and getting hold of counsel in other states. It was overwhelming, and you know, I certainly probably made mistakes in my own application that I believe to be absolutely true. So we took it seriously. Maybe we didn't review it quite enough. Maybe we should have just said, we're not ready yet. We need some more time to finish it. If we made a mistake, I think that was it. But it wasn't because we didn't take the document seriously and that we didn't understand. I will say that I still, to this day, question the idea that a 0.2% interest on a, I've just, the idea that we're qualifiers is still a bit funny to me because we're not part of sort of an MGM team. We broke up, but it didn't mean we didn't take the document seriously. We took it very seriously, and quite honestly, the volume of information for someone who's never done it before was tremendous. I think if you had that database and you filled them out all the time, it certainly would have been less onerous.
Other questions? All right, thank you very much.
I'll just say a word.
You may have a concluding word. Yes, sir.
You seem to be looking wrong like that.
Well, no, I was looking at the exit.
I've always been a straight man.
Just turn the microphone back.
I think I heard Attorney Wells at the end of her remarks observe that there was some provision in the contract between Blue Tarp and Rolling Hills Estate Trust, that if there was a disqualification, there would be payment and so forth and so on. The fact is that if Mr. Barletta or these gentlemen associated with the Barletta companies were disqualified from being qualifiers, I think that would have very serious ramifications for their business. They are constantly engaging in public bidding, and I think it would be hugely damaging to their business if they were disqualified for these bases. Thank you.
All right, thank you. Thank you, gentlemen. Thank you. We're now going to recess this hearing. We're not going to close the hearing. The commission will take all of what we heard today under advisement and deliberate, as the chairman said at the beginning, and as we have done in all of the other hearings, deliberate, reach our conclusions as to each of the issues before us, and issue a written opinion in the near future dealing with each of those. In the event that we need further information, the hearing remains open. We'll request that additional information